Good morning, everybody. Happy Friday Eve. Welcome to the Courtroom Files Live. Let's start our day in Michigan with Judge Dad.
To read it, understand it. If you plead guilty, you will be giving up all those rights and there will not be a hearing. Do you understand that? You have the right to an attorney. I'll be happy to appoint you one at public expense if you want one. Would you like a lawyer? I can't hear you, ma'am.
No, sir.
To the charge that you failed to pay $483, how do you plead?
Yes.
Did you fail to pay?
Yes.
Anybody force you to plead guilty?
No.
Is accepted. Why didn't you come and talk to me? I don't understand. Hang on a second. It's one of the most frustrating things. I almost let people determine how much they're going to pay, and then I tell them, if you don't have the money, come talk to me, but don't ignore me. And you didn't pay, and you didn't talk to me, and you ignored me. Why would you do such a thing? I don't get it. I don't understand it. Why weren't you in here with your money, and why didn't you come and take advantage of my nice offer to come talk to me on or before due date if you didn't have them? I don't understand it. That's one of the things I'll have to devote a chapter to in my book, because I just don't get it. I really don't. Why didn't you talk to me?
Well, I did call
Call who?
up here.
I don't get on the phone with people. I never said I'd get on the phone with you. And what did they tell you?
Well, when I was here last, you said.
You were here on April 24th.
You said if I cannot make the payment, call up here.
Call up here and go on Zoom with me, or come in on or before the due date in person. That's what I told you. That's exactly right. I didn't say call and talk to a staff member and tell them, hey, I can't make the payment. Is that what you're trying to tell me you did?
No, I called and I asked for a court date because of the fact that.
You didn't need it for it. You needed to come in here on or before May 30th.
Well, I wasn't able to come up here at the time.
Why? You live in Rockwood, right?
I understand, but
How far is Rockwood from here? How far is your house from?
probably maybe 10 minutes. But I have,
Do you work?
no, I don't. I just literally just started working on Monday.
Where?
I work at BTW for FedEx. I'm a admin.
Who do you live with?
It's just me and my son.
You gotta come talk to me. You gotta come talk to me. Come on. If I told you I was gonna give you $3,000 if you came here that day, you'd have figured out a way to get here. If you told me this is not yours.
This is my.
I know, but this lady isn't, right?
Yes.
Yes, I spoke to him.
I didn't even know we gave the lawyer. Okay, I see waived on the file.
That was already reviewed for point out of that.
I'm sorry then, I didn't know. I mean, I don't know how she got to you. How'd you happen to talk to this lawyer?
It was on the document.
Her assigned attorney previously
Yeah,
when
but
she
that
took
was
her
back-
plea.
That was back before the adjudication, so.
I understand all the 840s are time to pays.
At any rate, go ahead, Mr. Gage. What do you want to say? I'm not excited about the fact that she didn't bother to come and talk to me. I'm telling you, I don't get this.
I understand.
Your-
I did let her know.
Your appearance,
Good morning, Judge. Matthew Gates, the parent, the defendant. Judge, I did speak to Ms. Bryant and I did let her know that the courts made her aware at the time of sentencing, if she needed additional time to call. She did tell me that she did call, but whoever she spoke to told her to go ahead and just wait for some paperwork and then come into the court. That's,
they would never tell them.
That's exactly what was told.
Wait for paperwork, wait for a show cause, you call,
Yes.
hang on. You're telling me you called on or before May the 30th, and they told you to wait for paperwork, in other words, a show cause contempt hearing? If I knew who told you that, I would go down there, union or no union, and fire them right now. So if you know who it is, tell me.
I don't know the words. Said, or whoever.
They would never tell you that. They would never tell you that. Wait for the paperwork so that you can have a show cause filed against you? She doesn't have the money, right?
Money today, Judge, and then she just started a new job this week. She will need just a little additional time to pay the balance, but she does have, she said she's able to pay half of what is owed.
She's only gonna have to pay $200 today. And then I'm gonna let her set up her new payment plan. And then next time, so there's no confusion, I didn't mean to call and tell them you can't pay and get advice from them. They're not judges. Okay? I meant for you to call. I need to go on Zoom with Judge McNally to talk about time to pay, or you can come in here on or before your due date, in person at 8:30 in the morning. So all these time to pays are gonna be at 8:30 in the morning. All right, you pay 200 a day. How much can you afford to pay weekly or bi-weekly?
I can finish the payment next Friday.
I don't need you to fix your, how are you eating if you haven't worked in 4 months? And you got a son and you just started working? Is that not what you told me?
I literally started working with for my first check, they get paid bi-weekly. So with me working this week, I get paid next Friday.
You're still gonna owe $283. You don't need to pay all that now. It's not my intent to make somebody not eat. It's my intent to show people or at least try to convey to people, you need to have the slightest amount of respect. I can let her pay 50 a week, 40 a week, whatever you want, Mr. Gaith. I'm gonna make it $50 per week, but you can pay it. But you can pay it,
She's able to do $50 a week, Judge.
and I'll start it October the 13th. I'm sorry, October the 17th. That's okay.
Thank
If
you.
you need more time, you're gonna come talk to me, right?
Yes.
If you want to pay more, you can, but all right, good luck. Terrence Arnold Hall, 25T 646-123. You're welcome.
Good morning, Judge. Madison Gates, apparent on behalf of
Mr.
Mr.
Hall, come on up here and state your name.
Judge, Mr. Hall is a little bit hard of hearing.
Okay, I'm sorry. Your name, sir? Your name?
Terrence Arnold.
All right, so as I understand it, he's going to plead guilty to no valid acts, the suspend to be dismissed, right?
Correct.
Is that what you want to do?
Yes.
If you do that, the possible penalties are up to $100 fines, 90 days jail costs, or all those. Do you understand that?
Yes.
Did you sign an advice of rights form here today?
Yes.
Did you read it and understand it?
Yes, sir.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
All right. To the charge, no valid operator's license on person. How do you plead?
How do you plead to the no valid license on person?
Okay.
Were you operating a motor vehicle on West Jefferson near King and Trenton, August 7 of 25 at 8:59 in the morning? Yes?
Yes, yes, ma'am.
Did you have a valid license with you on your person?
Yep.
I can't hear you.
Yes, sir.
You had a valid license on your person that day?
No, sir. No.
You're not even licensed. You're not even licensed, are you?
No.
Why are you driving?
Working?
You can't drive without a license.
Yes.
How old are you?
65.
Did you ever get a license?
I'm trying to get them now.
You've never had a license before?
Have you ever had a license?
Oh, yes.
When?
Back in 2011.
I don't know what to say. If you want probation or parole,
No.
anybody force you to plead guilty?
No.
You can't drive without a license, sir.
Yeah.
Plea is accepted to no ops. The suspend is dismissed. Anything you'd like to say on sentencing, counsel?
Just that I've explained Mr. Hall the procedure to go ahead and get a license. And he's gonna go ahead and work on that in the interim and then hopefully this won't happen again. Is that correct, sir?
Where does he work at?
Myers.
All right. Anything else you want to tell me?
You want to say anything to the judge, Mr. Hall?
Yes.
Go ahead.
Well, I used to work with Amazon. I was terminated from there in May. Yeah, and I just started working at
Okay, $100 fines, $175 costs. I have to charge a $75 victim's rights fee, $50 justice assessment, $40 in attorney fees, $440 or 90 days.
Do you have that to say today, sir?
could pay next week.
All of it, or you want a payment plan?
Yes,
You want a payment plan?
yes, sir.
How much can you afford to pay?
Uh,
How much can you afford to pay? It was $440.
100 a week.
I'll make it 75.
Thank you.
75 per week, beginning on, I'll give you some leeway time, October 17th. If you need more time to pay, no problem. Call the court. We'll go on Zoom on or before any due date. And I'll be glad to give you an extension, okay? Or you can walk in here on or before any due date that you don't have the money. Good luck. Any questions?
No, sir.
All right, good luck. Thanks.
Thank you.
Chelsea Leanne.
Good morning once again, everybody. Welcome to the Courtroom Files Live. Happy Thursday. Let's switch it up. We'll go
It's
to...
the same name?
Whoop. Shush. Let's go to Judge Simpson. Say good morning to him.
Good morning, Your Honor, and then on behalf of the people, Your Honor, the people waive any potential conflict between this honorable court and the office of the public defender. While the people don't believe such a conflict exists, we make this waiver and appoint it to public.
Oh, boy. Mr. Brown, I wore my Maryland red for you. Go ahead, sir.
Good morning, Your Honor, and congratulations, Mr. Laura Brown, Deputy Chief Public Defender. Your Honor, we likewise do not believe that any conflict exists in this honorable court hearing these matters. If a conflict were to arise, we would waive such conflict so that this honorable court could hear these matters.
Thank you, sir. And the court, for its part, also does not believe that there's conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matter. The court does call the case of the people of the state of Michigan versus Romeo Smith.
Good morning, Your Honor, Ashley Lonnie Belvis for the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Smith, Your Honor. I don't believe
Yes.
he is he. Okay.
Mr. Smith, can you state your name, please? Okay, you might have to do that for me again. I think you broke up.
Muhammad Martinez Smith.
Thank you, sir.
And Your Honor, my understanding is that he's still incompetent, but restorable at this time. I believe the last report we got was back in either late August or early September. He's still being treated at the CFP, however, so we would just ask for a little more time.
The last report I have is August 21st, dated August 21st.
Yes, that makes sense, Your Honor. Yep.
All right, did the people have any additional information?
No, Your Honor, we would simply to that continue report the finding of being incompetent, but likely to retain competent or restore competence, and ask the court to skip the jury date.
All right. The defendant remains incompetent but restorable. I will set this. Problem is our trigger dates are going to roll into the holidays, so we're going to give you something close, but we'll move it if we get a report in. 23rd.
Yes.
Okay. All right. I'll adjourn the competency hearing in this matter to December 23rd, 2025.
My birthday.
Oh, it's not.
It is.
You're like a Christmas baby?
Yeah, kind of.
Surprising. In a lot of work. I'll explain why. I probably shouldn't do that. All right. Bond will continue.
Thank you, Your Honor.
Court does call the case of the people versus Carlos Edwards.
Good morning, Your Honor, Victoria Burton Harris on behalf of the people.
Good morning, Deputy Chief. We missed you.
I missed you.
Well, thank you. All right. Who's on this? Pardon? Oh, really?
Your Honor, I'm sure she is walking through the door.
No, Cannon, there is no telling where she is.
I saw her in the hallway working hard.
Yeah.
She just had to make her way inside to continue that hard work.
Where is she?
Right there, Judge.
Stephanie Cannon on behalf
Well, good
of
morning.
Mr.
You just come up and
Edwards.
say your name. You don't even say good morning.
Your Honor, the goodest of mornings to you.
You realize that you had an attorney defend in your absence.
Yeah.
Yes. Chief
Yes.
Deputy Prosecutor.
I had the best, Your Honor, for the.
No, not them.
Oh.
They were putting you under the
They
bus.
threw me under the bus?
They were putting you under the bus.
Did
Ms.
this
Burton
honorable-
Harris was defending you.
Where's my girl? Thank you. Thank you. Your Honor, on behalf of Mr. Edwards,
Mr. Edwards, can you state your name, please?
Carlos Edwards.
Thank you, sir.
Your Honor, I actually did not have the opportunity to meet with Mr. Edwards. When I called the facility, I am not on any sort of listings, so I need to get on some listings so I can visit with him. I am asking for just a 2-week adjournment. My intent will be able to see him hopefully by Tuesday.
He's in MDOC.
Yes, he's at the Central Michigan facility.
Right, but I guess if I'm looking at a 2-week adjournment, my concern is that, as I understand the process, there has to be an application and an approval process, and that hasn't occurred in that brief period of time.
Okay.
That's been my experience. I mean, I'll give you a 2-week, but I don't think it's going to work. Why don't we do this? October 16th. I'll give you, yeah, let's do that. Probable cause conference will be adjourned October 16th. And then hopefully you can start that process and we'll at least have some indication as to what we do.
Thank you so much, Your Honor.
All right. Thank you, Mr. Edwards.
Yeah, you're welcome.
Court does call the case of the people versus Carista Riopel.
Morning, Your Honor, Ashley Bellis for the people. She's in Zoom.
He's here.
Oh, morning, Your Honor. Mike Getty, Assistant Public Defender for Ms. Riopelli. Could you state your name, ma'am?
Carissa Riopel.
Thank you.
Your Honor, I think we have this. I have some news I need to deliver to Ms. Riopel that I think will settle this case. I will personally go out there. I had planned on doing it before I went off on medical. I think we are in a position, Ms. Londi has tendered an offer that I think will resolve this matter. I'd ask to adjourn it one more time so I can drive to DOC and actually go over this with her.
Drive down, it's like 5 miles.
Exactly.
Okay. Well, October.
I know the direction, so apparently others may.
Will October 9th work?
That'll be fine, Judge.
All right. And I'm going to adjourn your probable cause to October 9th, 2025, 9 a.m. Bond will continue. All right.
Thank you.
Thank you, ma'am. Court does call the case of the people versus Andre Flores Nava.
Good morning, Your Honor. Victoria Burton here, appearing on behalf of the people.
Good morning, Your Honor. Michael Vincent, appearing on behalf of Flores Nava.
Your name, sir?
Andres Flores.
Who's here with, oh, there she is. Okay. Thanks. I just wasn't going to go ahead unless.
I wouldn't want to go blind.
All right. I'm still, it's like PTSD. All right, what are we doing on this case?
Your Honor, this is date and time set. Probable cause conference. We're asking for a waiver, circuit court.
All right. So you're waiving your right to a preliminary examination?
Yes, Your Honor.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, Your Honor.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 following. Mr. Vincent.
Yes, Your Honor.
You acknowledge receipt of the information
Yes.
waiver reading. Your client stands mute at this time.
Yes.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea as to both counts. Pre-trial will be set for
October 8th at 1:30.
October 8, 2025, 1:30 before Judge Conlon.
Your Honor, could I address the bond?
You may.
what is his bond at right now?
I have his bond set at $10,000 cash sure.
Is there any chance to make it 10%? He has a hold out of Wayne County. We hope to get him out of that hold. It's circuit court.
Well, you mean you want him to go to Wayne County to deal with that?
Yeah, but I want a bond on him so he's earning time. If we could have $1,000 bond, 10%.
Well, I would have some concern about him going to Wayne County because we have to make sure to get him back. What my problem is.
I'm asking for a bond, just a lower bond.
I heard you. I mean,
He'll come.
I understood what you were saying, but
I don't, so I'm glad you do.
Any response from the people?
We're gonna leave it to the discretion of the court. I do understand the intent of the request. I also understand the concern the court has about his return. Should he bond out and go to Wayne County? But people also share in that concern, so I will leave this to the court's discretion.
He'll come back, Your Honor. If not, I'll go get him.
You'll what?
I'll go get him if he doesn't come back. I will.
Oh, I thought you said we could take you.
I'm too old.
All right. I'll give it a shot. I'll grant the motion to modify his bond. I'll set his bond at an amount of $1,500. I'll give a 10% privilege.
You're right, $1,500, no 10%?
1,500, 10%.
Thank you, Your Honor.
All right. Thank you.
Don't make me get out. All right. Don't talk on the phone.
Court does call the case People versus Jason Poland.
Andrew Manis for the people.
And good morning, Your Honor. Assistant Public Defender Chinazi Kariakin on behalf of Mr. Jason Poland.
Miss you too. Or they did. I did.
Oh, Your Honor, I missed you.
Mr. Poley, he's got to get somebody done, you know. Sir, can you state your name?
Jason Allen Poley.
All right, thank you. What are we doing on his case?
Your Honor, we respectfully request that both of these matters be set for preliminary examination.
And what date are we on?
October 7th.
So discovery is complete, I'm sorry.
To my knowledge, Your Honor, there is one body cam video that I've already requested from the people earlier this week. I don't think that it should stop us from proceeding.
And so there's an understanding that if that's not provided, that won't be a basis for the adjournment.
Understood, Your Honor, yes.
All right. People have their witnesses available the 7th.
We will do our best, Your Honor.
Preliminary examination in person will be set October 7th, 2025, 9 a.m. That is before Judge Perry.
Thank you, Judge.
Thank you. Bond continued.
I'll take him back.
All right, take care, sir.
Thank you, Your Honor.
Court does call the case People versus Marvin Sullivan.
Michael Vincent on behalf of Marvin Sullivan. Mr. Sullivan, what's your name on the record?
Mark Sullivan.
Thank you.
We need a date for a prelim exam, Your Honor.
Discovery is complete.
Yes.
I believe that it is, Your Honor.
Yes. It's been a long time at Pittsfield Police going over everything. And Amanda says we have everything.
All right. Would people have their witnesses available the 7th?
October?
Yes.
I can attempt to do that, Your Honor. I do believe that we're going to have a handful of witnesses, so.
I don't know what that means. You won't be or you will be?
I'm going to attempt to have everybody there, yeah.
Your Honor, if I may, The Pittsfield detective stated they would not be available that day, from the October 6th to the 17th.
Thank you.
You're welcome. You're welcome, John. After the 16th.
All right. You said the 17th.
Correct. So 6th
Okay.
to 17th.
Preliminary examination in person will be set October 21st, 2025, 9 a.m. That's before me. Bond will continue. Court calls case People versus Anthony Alexander.
Andrew Banish for the people.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Alexander. Mr. Alexander, could you please state your name?
Anthony Alexander. Thank you. You're asking for an adjournment.
Yes, Your Honor.
Probable cause conference will be adjourned to October 9th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Take care. Court calls case People versus Andrew Gendy.
Morning, Your Honor. Andrew Santa, appearing on behalf of Mr. Gendy.
Jennifer Douglas for the people.
Be present. Is your client present, Mr. Fanta?
He's in lockup, Your Honor.
Oh, he's in custody. I'm sorry. So we have him, yes. I didn't see the purple tab or anything. Sir, your name?
Andrew Gendy.
All right. All right, what are we doing?
Your Honor, I would ask for an adjournment on this PCC until the 16th of October. At that time, if we are unable to resolve the matter with the people, we will be waiving our preliminary exams.
Any objection to the adjournment?
Your Honor, the people will not object to that.
Probable cause conference will be adjourned October 16, 2025, 9 a.m. Bond will continue.
Thank you, Judge.
Thank you.
All right, bonds will continue there with Judge Simpson. Let's go to Miami-Dade, see how Judge Glazer's doing this morning.
It's for you. He has an open trespass, so I don't know, state.
But I think there may be issues with the stop and with residue. Ms. Court, you want to tap?
Okay. One moment. Or set it for a probable cause hearing. Whatever you want.
My client wishes tap, Judge.
Okay, I'll find, you stipulate that to any piece to PC?
Right. Oh, we'll waive.
Or waive the
argument.
waive the PC
Yes.
arguments. All right, tap alternate bonds. Count one will be $1,000. Count two is $500. Sir, you have to come to court for your arraignment on October 27th at 9 a.m. Courtroom 7-4. Judge Milton Hirsch. Have a good day. Next, Markel King, page 5.
There's an AC, no bond.
There's a hold for F25 17687. Good morning, sir. You were arrested for 3 cases. They are sale of cocaine for 2 cases, and then deriving support from proceeds of prostitution and renting a space for prostitution. You also have an open case. There's a hold for F25 17687. I will appoint the public defender's office for you. So it looks like he sold, was it to was it a CI or a UC? Let's see.
I think it just says
a use undercover
agent, so I'm assuming it's a CI.
Oh, the agent, I'm sorry. right. So there's probable cause for sale of cocaine from September 5th. That bond is $7,500 with the hold.
Case was that, Your Honor?
F 25-20923.
7,500.
Yes, ma'am. Next case I'm reviewing is F 25-20922. That's from September 2nd. There's probable cause here as well. $7,500 bond with a hold. And then F 25-20907. I need to review this. It's from July 15th.
He let someone live with him and then he.
I exchanged,
She engaged in prostitution to pay the rent.
okay, there's probable cause for the charges. In this case, it's 77, what do you want me to set these? 7,500 count 1, 500 count 2. You'll see your judge tomorrow. Have a nice day.
We can recall a Roscoe whenever the court's ready.
Okay. Recalling Teddy Orozco, please.
Morning, Your Honor.
Good morning.
I haven't seen the arrest form yet, so I'm not prepared to make any arguments at the moment.
Fine, we'll reset it for the afternoon.
Thank you, Judge.
I'm going to
You need
reset
to
your case
email
for
the
the
clerk's
afternoon
office.
so your
Thank you,
lawyer
Judge.
can review it.
Thank you. 1:30?
Yeah, 1:30.
Okay, I'll see you then.
Okay. Oh, I made the preliminary finding of probable cause. Florian Bruss. Good morning, sir. You were arrested for serious charges. I will appoint the public defender's office for you. It's from May.
So I don't know if the charges are correct. Count 1 is charged as a sexual battery, but I think based on the age of the victim, there would have to be no consent for the sexual battery, and it looks like it was consensual. So the more appropriate charge, I believe, is lewd and lascivious battery, which is a second-degree felony. In terms of
Lascivious
count
battery? Wait a minute.
in terms of count number 2, it's charged as though he met the minor or brought the minor in from out of state. I don't think that's alleged. I think the more appropriate charge there would be custodial interference. And then there would be probable cause for the contributing to a delinquency.
Okay, let me take a look. So he's 24. I guess he met the victim over Instagram. Then after
he's 14,
conversing for several months, then he meets in person with the victim. He ordered an Uber and traveled from his residence to the victim's residence. A 14-year-old. The victim was 14. So, all right. So, sir, you are ordered to stay away from the alleged victim, whose initials are RJ, the 14-year-old child. No contact with the victim, either directly, indirectly, in person, in writing. by telephone or through third parties, no contact with the victim through social media or other electronic means, and you must stay at least 500 feet away from the victim, her home and school at all times. Do you understand the stay away order, sir?
Yes, ma'am.
State, are you sure that's right? Because she's under 16.
That's, Judge, I agree with her. I reviewed the statute
Okay,
before court. I came to the same conclusion.
okay, very well. Then I will set a bond. Count one. There is probable cause then for lewd and lascivious battery on a child. That's a $7,500 bond. Count two, there's probable cause for custodial interference. Is that a misdemeanor or felony?
Third degree felony.
That's a $2,500 bond. In count three, there's probable cause for contributing to the delinquency or dependency of a child based on the fact they gave her a vape, a cannabis vape.
And also engaging in the conduct with her as well.
That is a first degree misdemeanor. That's a $500 bond. So stay away from the victim. Good day, sir.
She seems to be doing pretty well. We'll check back in when it gets closer. Check back in on her when it gets closer to lunch. Let's go to Texas, Judge Stevens.
Bond condition hearing dash VA court update. I don't know what the heck that is.
Yeah, this is Mr. Laird and I had talked about. He was doing a veterans court and has successfully completed the treatment program and whatnot. But so everything's going really copacetic.
Where or is this headed? I mean, we're not going to have a trial on this, right? It's going to be disposed of without a trial, or is it a
Yes,
trial?
sir.
My information is he's not cooperating with Veterans Court, Judge, so we're already in opposition.
Well, we got a certificate.
I'm going to go based upon the information my office has provided, Judge.
Okay, well,
I appreciate he's holding a certificate, but that's not what I'm being told.
Well,
What are we here for today?
In the meantime, Judge, what we're asking is that the I do my notes. The asking the court to modify the bond restrictions to get rid of the requirement for the ankle monitor.
Why does he have an ankle monitor?
I'm not sure why he has it. It's just
Probably the nature of the offense, Judge, just from looking and knowing their tendencies.
I don't understand.
Yeah, and
I guess was there a condition? Was there a condition of his bond that we have no contact with the child? Is that what happened? Or is that not right? Is that right?
Yes.
Okay. Where is the child compared to where you live?
No, the child is actually with his grandmother.
His grandma? Okay. Nothing, but doesn't live in the household with you right now?
No, sir.
So on November 14th of 24, Your Honor revoked this defendant's bond because he was having contact with the child. It was after that that he was placed in the Veterans Court. So it would make sense, Your Honor, with your norm that you traditionally put some type of conditions if you'd revoked a bond and place those conditions.
Where are we in the Veterans Court thing? He's completed it?
That's what they're saying. I'm seeking information from the chief.
I'm asking you if you want to.
I did complete it, and I learned a lot through the program.
Okay, what did you have to do to complete the program?
It was 8 weeks, just basically just online courses with Miss Dozier, counselor, and basically
Miss Mosier?
Dozier.
Dozier.
Just taught us about substance abuse and disorders and stuff like that.
Okay. So this looks like you just received this on September 13th?
Yes, sir.
Okay. Last week or so, a weekend or so ago. Okay. Will you make a copy of this, please?
That's the court's copy.
Is I want to give it to him?
I gave him a copy.
Oh. Good work on all those copying things. That was quick.
Anytime.
All right, so this is received on behalf of the defendant. All right.
I would ask,
I'm just sitting here feeding Ellie yogurt because she loves yogurt, and that stupid Judge Stevens just cuts his feed for no reason. Why does he do that to me? In the middle of me feeding my cat. It's rude. I tell you, it's absolutely rude. Let's go back to Judge Simpson.
Okay, thank you, Judge.
Thank you. Court calls case People versus Diego Rodon Pardo.
Good morning, Judge. Kyle Burdell filling in for Bill Amadeo on behalf of Mr. Rondon Cordon.
Your name, sir?
Diego Rondon Cardone.
Okay. You have any objection to counsel stepping in for your attorney of record?
No, sir.
All right. Thank you. Thank you. What are we doing?
Your Honor, speak with Mr. Amadeo. We are just asking for a 1-week adjournment or whatever the court's next available date is to work out a global resolution in this matter.
Well, is 1 week going to be enough time to do that? Thank you.
Sure.
Probable cause conference, October 9th, 2025, 9 a.m. Bond.
Thank you, Judge.
Thank you. Oswego County. Okay. There's a gentleman who is signed in from Oswego County Jail. Can you give us your name, please, sir?
Robert Greenshields.
He's not. You heard his name.
I heard
his name. Sir, you're not on our docket. Do you know who you're supposed to be appearing in front of?
No, sir.
Okay. Do you have a case in Washtenaw County?
Yes.
Trevor Mayville for the people, Your Honor. I believe he's set for a 3 p.m.
Yeah, no, 3 p.m.
Yeah, with Mr.
And Mr. Kilowald's not here. All right, they signed you in early for, did we not know? We didn't know he was in custody. All right, sir, is Mr. Kilowald expected? Try to get through to Mr. Kilowald, see if we can get, what we're gonna try to do, you're on our docket at 3, but since you're signed in right now, we're gonna try to get your attorney here if we can and try to deal with your matter while you're here, okay? So it may be a little bit of a wait, but we're gonna work on that, all right?
Okay, Your Honor.
All right, thank you. Court does call the case, People versus Malik. Is it Arcidi?
Malik Saidi, yes, Your Honor.
All right.
Stephanie Cannon on behalf of Mr. Sadiq, Your Honor. Victoria Martin here is appearing on behalf of People. Your Honor, may we approach for just one moment?
One of you can take a guess. No, come on.
Everybody's cutting out on me today. Back to Judge Glazer.
I was born here 22 years ago.
Pretrial services, alternate bond, $2,500. So sir, make sure to keep all future court dates. You may be eligible for the drug court program. That's something you should discuss with your attorney. Next is George Otero, page 7.
Spanish interpreter, please.
Good morning, sir. You were arrested for possession of cocaine and possession of drug paraphernalia.
Buenos días, señor. Usted fue arrestado por la tenencia de cocaína, excuse me, y tenencia de accesorios para cometer delitos relacionados con droga.
I will appoint the public defender's office for you.
Voy a entonces a nombrar la Defensoría Pública para que lo represente, señor.
There's probable cause for the charges.
Existe motivo fundado para los cargos que se le imputan.
Criminal history to the 80s.
Right.
Tiene un historial penal que llega hasta los años 80.
Yes,
He was
Miss.
released from prison about 2 weeks ago, September 11th.
Okay. Y hace 2 semanas fue liberado de la prisión el 11 de septiembre, su señoría.
What do you want, a bond or you have an objection?
Yeah, he got out of prison 2 weeks ago.
Would you consider tap, Judge?
No, he's getting a bond. Count 1 is $2,500 and count 2 is $500. Good day, sir.
Okay. La fianza por el primer cargo son $2,500, señor, y el segundo $500. Tenga buen día, señor.
Next case is George Williams, page 8. Good morning, sir. You were arrested for battery by strangulation. Sir, can you afford to hire an attorney?
No, ma'am.
I will appoint the public defender's office for you.
Thank you, ma'am.
He's his adult son, and I believe he lives at a separate location.
There's probable cause for the charge, sir. You are ordered to stay away from George Williams III. No contact with the alleged victim, your son, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim, his home and school, and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs, and do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you understand the stay away order, sir?
I understand, ma'am. I have one question.
Yes, sir.
Would you consider a reduced bond, Judge?
Sure.
Okay.
You can afford about 2,000. He surrendered to the police, Judge. He even contacted the police.
All right, $2,000 bond. Good luck to
One
you,
moment.
sir. Next is Jonathan Morales, page 8.
Bond out.
Thank you. Joshua Astacio, page 8.
Fugitive from Osceola County with no bond.
Thank you. I think it's just possession of cocaine.
Right, but it's kind of interesting. There's so much money, but not a lot of drugs.
Good morning, sir. You were arrested for sale of cocaine and possession of cocaine. I will appoint the public defender's office for you. So they found him with $10,000 in US currency as in his pants pocket. In his wallet, in his wallet was another $650. He had a large plastic bag containing cocaine weighing 3.5 grams. Actually,
Maybe
I think that you're right. I think you are correct.
Right. So I don't know if that money has more to do with the attempted murder out of county. Would you want to do $1 count one, 2,500 count two?
That's fine. I'll find probable cause. $1 count one, $2,500 bond count two. You have a warrant from Osceola County for attempted murder. Once you post the bond on this case, then you'll be on our calendar for you to be picked up by Osceola County.
And for the record, we'll be invoking Mr. Estasio's right to counsel and his right to remain silent.
Okay. Thank you. Next, we have Angel Mercado.
They always deal with such light matters in Miami-Dade. You know, just an attempted murder, allegedly, right there. So let's go back to Washtenaw County, but instead of Judge Simpson, we'll go to 14B. This is normally Judge Washington's court, but she has a substitute judge in there today. This is Charles Pope. Let's see what's going on with him.
Mr. Kimura, good morning.
Good morning.
What is your, are you still on Delaware Street?
Yes, sir.
Who do you stay there with?
My mother and children.
How many kids do you have?
2, 8 and 10.
How are they doing?
They're fine.
You know, it's going to be pretty terrible for the kids to have to go to school knowing that daddy's in jail. You're past due in doing something about your addiction. You're suffering from a disease. And like all diseases, it may not always be curable, but it's manageable, just like diabetes. But you got to take this moment in time to get serious about it and actually take some positive steps in your life. I'll continue your current bond, but I'm adding some conditions to it. One condition is that you're to attend 12-step meetings on a daily basis, beginning today. Okay. You are to test 3 times per week with community corrections and enter your substance abuse treatment facility at the first available opportunity. And then when we see you back on October 23rd, we'll expect proof of your AA meeting. So make sure you keep your sheets. Continue to test 3 times per week with community corrections, and then do your best to get into a residential treatment program before we have to force you into it. It's always good to us to see that somebody's doing it on their own. You know what I mean?
Yeah.
Understand everything?
Yep.
All right. Good luck, sir. You're all set.
All right. Thank you.
Wow, Bailey, thank you. Throwing down 20 gift memberships. You're a very good friend and very supportive of everything that we do here. And I really appreciate that. Thank you so much. Seriously, thank you.
280.
Tiffany Woods for the people.
Good morning, Your Honor. Justin Zaid, appearing on behalf of Ms. Sarr, President consents to appear via Zoom. Ms. Sarr, can you state your full name for the record?
Ms. Sarr, can you state your name, please?
Yes. My name is Mam Pendasar.
Thank you.
Your Honor, this is the day and time set for a pre-trial. I was recently retained. I intend on tendering a deviation request to the prosecutor's office, so we are asking for an adjourned pre-trial date.
Ms. Woods, any objection to the?
No objection, Judge.
Okay. Counsel, how much time are you looking at?
3 weeks, if I could, Your Honor.
Okay, that's October 16th. This pretrial conference is adjourned at the request of the defendant with no objection from the people to October 16, 2025 at 9 a.m. And in the meantime, the court will continue bond.
Thank you very much, Your Honor.
Okay. Yes, sir. Thanks, Ms. Sarr. You're all done.
Thank you.
Am I doing the in custody right now? Okay. People of the state of Michigan versus Derek James Riles. This is case number 250242.
Tiffany Woods for the people.
Ashley Martin on behalf of Derek Riles. They are on Zoom, not in custody. I know there is also another Derek Riles that is scheduled for a PCC today. I don't know if that's who that is.
Oh,
Bill.
Mr. Riles, can you hear me, sir?
That's what happens when I let Trap do stuff.
Mr. Riles, can you hear me from the jail?
I'm sorry, Your Honor. He's changing my name. That's not my name.
Okay, very good. Thank you. What is your name?
My name is Bryce Valerio, Your Honor.
Thank you. Sorry about that.
No worries.
Is Derek Riles available? Is he online?
Yes, she is. Unmute and say state your name, Derek.
Hi, good morning. Derek Riles here.
Okay. And once again, this is State of Michigan versus Derek Riles, case 25S242.
Judge, today we're here for the first pretrial. Derek completed an assessment and I sent those results to Ms. Woods and we are waiting for a plea offer. So if we can adjourn this matter.
Judge, I also received a community corrections bond violation that the defendant tested positive for alcohol on August 16th and also had several late tests. I believe she admitted to drinking tequila.
I have a report in front of me dated September 24th. Oh, involves all drug testing and not. No, it's a sober link. The report I show, Ms. Woods, shows all negative results.
The report I received on the 24th, let me see when it's dated.
Mine is dated the 24th yesterday. And it's a sober link report.
Mm-hmm. If you look at the bottom of the report, Judge.
Oh, I see. Yeah, in
she is-
August.
where
Yeah, there were.
the late tests and then the positive.
Yeah.
We are able to address that. Ready?
Go ahead.
Ms. Rouse does admit to the late test and the one positive test. Regarding the late test, she works midnights and also is a student. I actually was there for the arraignment and we discussed different things to stay on track with the timing. There has not been any late tests since then. There was a one positive test that she admits to. We are requesting a personal bond in this matter. She does take accountability for the positive test. Again, it is one violation since having it. She has a lot of personal issues going on top of, as I stated, working full-time as working as a pharmacy tech and also is a student at Washtenaw pursuing a biology degree. So we're just requesting to continue on the sober link and a personal bond. There are also some drug tests that I wanted to address as well, a drug testing that she has, I would like to address.
Go ahead.
No violations there either. Drugs was not a factor in this case. We are requesting the removal of drug testing or at least a reduction.
Insofar as the adjournment is concerned, Ms. Moten, how much time did you think you needed?
Ms. Woods, how long would it take for you to review the report?
Judge, I would need a couple weeks to review everything, and I believe this defendant also may have some new cases and some new DV cases that were also, I don't know if those were a bond violation that she was arraigned on just yesterday.
That's my father. So sorry to interrupt. We keep getting confused. We do have the same name. Keith even called me yesterday about my father. Throughout this entire thing, I keep getting associated and confused with him. We have the same name, different birthdays. He's in jail now. That is not me, though. Sorry.
Thank you. Oh, you don't have to be sorry. I'll adjourn today's pretrial conference to October 16, 2025 at 9 a.m. for an additional pretrial. Ms. Ross, I'm disturbed about the August 16th incident. I respect the fact that you have owned up to it. And I do notice that since that time, there have not been any other violations. What led up to that relapse, I'm wondering?
I really have to say it's probably just stress. And it was a really poor decision. I was aware of something. I mean, I knew it's something that I shouldn't have done. I wasn't really being very conscious of it. But I think just with life and work and school and personal issues, it's just been kind of a difficult process with restraining myself. And I don't really think that I have a problem per se. But
Well, you do. And let me tell you why.
I was
You know, one is that you're dealing with stresses in life with substances, and that's a problem. You know, everybody has stresses in life, but you need to know how to direct those stresses and to deal with them other than by the use of substances.
Of course.
You're charged with having a high BAC, and that's an extremely serious offense. So, you know, there's that. And knowing that there's a court order directing you not to consume alcohol, and yet you chose to do so anyway, is a decision on your part to put your own freedom in jeopardy. And that's a problem. So yes, for those three reasons, it's a problem. I respect the stresses. Everybody's got stresses in life. You know, you're not the only one. But you have to learn how to deal with those stresses in an appropriate way that does not involve the use and misuse of substances. That's the key here. I'm willing to continue your bond on the case, including the drug testing in the meantime, but please be aware that 2 strikes and you're out. So make sure you stay together with your schedule on the sober link. And if you are dealing with stresses that tempt you in this way, then you have to develop other ways of dealing with them. Understood?
Yes.
All right. All right. Good luck to you. You're all set here today then.
Okay. Thank you.
You're welcome.
I don't know about you guys, but I rather like this guy. Fairly plain spoken. Seems compassionate, fair, yet firm. Seems to get the job done. I wish we could see him more, but I'll have to look, see if he's in another court that perhaps he streams, but he's nobody I've seen before. Continuing Washington on, we'll go back to Judge Simpson.
And I got in. Pardon?
He was on his way to an assessment, he said.
And what happened?
This.
Intervene.
This. Your Honor, I can approach with an explanation.
I want to hear it. Come on.
No.
You don't want to come? You don't want to explain?
No.
You don't want, so,
For HIPAA reasons, Your Honor, I can't go on the record. I cannot go on an open record, but I have consent to disclose privately.
well, then I'm not changing any. I need to know. That's an unusual circumstance.
With the permission to approach, it would
No,
bring
I'm
clarity.
saying, come on up. I want to hear it.
And just that quickly, he mutes again. These judges are out to get me today, I swear. Let's... Judge McNally. Let's try that. He usually doesn't mute.
Defendant pled guilty to allowing an unlicensed driver to drive, and she also pled responsible to failure to yield. Go right over to that microphone. You don't have to go in there. Come on out.
Right there.
Your name?
I don't know.
Thank you. He's seeking restitution. Your client pled guilty to allowing an unlicensed driver to drive. She also pled to failure to yield. You did a great job leaving the scene of a property damage accident. Suspend charges dismissed. Did you have a chance to review the victim's statement?
We have, Judge, and I did advise Ms. Eldridge that there may be restitution owed in this case.
Was this covered in any way by insurance? What would you like to say?
Judge, just that Ms. Eldridge, since the time of the accident, has taken steps to get a valid license. She currently does have a valid license. And it was not her intention to leave the scene at the time. It was just the way that.
God picked her up and flew her car away?
No, Judge, she would intend to go around the block because there was an issue with parking. She was right across from where she actually worked. And by the time she had made it down the street and coming back on the way, she was stopped by the officers. But she did advise me that it was not her intent to leave, Judge, but she does understand that she should not have left. She should have stayed there until the officers arrived.
Anything you'd like to say?
No.
So he's got two bills here. Right? Well, how much is your total here, young man? You got $399.73.
Those are just different estimates.
Here's what I'm doing. How old's your car?
It's a 2011.
I'm not going to give you this until you get it fixed. Okay? So, I mean, I don't want people collecting money based on estimates and then not getting it fixed or going to their insurance company and essentially double dipping. So I'm simply going to fine her. You go get the car fixed if that's what you choose to do. If you choose to choose not to go through your insurance, and I'm going to set a restitution hearing on this. Okay. So I'm going to put this out. I'm going to sentence her now, counsel.
Okay.
And I'm going to order her to pay restitution as ordered following a hearing. Anything that you would like to say, you want me to consider, sir, before I sentence her?
Just like to say, it was not my awareness that she was going around the block. It was my understanding that she was just going to the parking lot next door. I was going to call the police either way.
And then what'd she do?
So I was in the parking lot, and it was on the parking lot. I understood that she was going next door. I don't know why she even needed to go next door. She said
you don't think I bought that, do you? You don't think I bought that, do you? I've been doing this since I was a kid, practically. I don't buy that. That's
that building she went across the street to was where she actually worked. Her phone ran out of batteries. She had gone to make a phone call at that point.
You don't have a cell phone?
It ran out of batteries.
It was that. I went over.
Why did you need to make a phone? Why did you need to make? Let's not make this worse than it is, okay?
To let my fiance know that.
That wasn't your obligation. Your fiance is not the police. You needed to
He
call.
told me he was called to the police. That's why.
How long did you wait there?
Immediately called the police.
And then the police showed up how long after? And was she back yet?
The police showed up and they.
Wait, don't interrupt him. Say again?
When they arrived, they informed me that they already accepted her.
All right. Anything else anybody wants to say?
Nothing else.
On the allowing unlicensed, and you don't want to say anything else, right?
No, yeah.
On the allowing unlicensed driver to drive, 100 fines, 150 costs, 75 victim's rights fee, $50 justice assessment, 40 in attorney fees, plus you're going to pay restitution as ordered following a hearing. I'm going to set a hearing on the restitution. You owe 195 on the failure to yield. So your total here amounts to 610, and then you're going to have to pay restitution, which do you know what the total amount was?
The estimate was 300, the lowest, the highest was like almost 500.
All right, let's set a restitution hearing in 4 weeks. That'll get you just, you'll be able to save some money, okay? Set for October, whatever, Lisa.
October 23rd, 8:30.
At 8:30, all right? Now, can she pay this money or does she need time?
She'll need a pen.
Does she have anything?
Yeah.
Where does she work at?
Work at Success on the Spectrum.
She works with autistic children.
All right, I'll tell you what, can you pay $50 per week?
Can we do 40?
$40 per week. I'll start it beginning October the 10th, okay? Now, if you need more time, I don't have a problem if you don't have the money. You gotta call the court. We'll go on Zoom on before the due date at 8:30 or come in here and see me, okay?
Okay, Your Honor.
So $40 a week, we'll have you pay on the B file first, and then you're gonna pay 40 per week after fines costs paid on B. That's on the A file, you'll pay that secondly, and then we're gonna have the restitution hearing October 23 at 8:30. So you can go down the hall, get your notice. I want you to get that notice too, and then you bring me proof that you've either that you had it fixed or that you've taken it to your insurance carrier. You take it to your insurance carrier, technically they're allowed to subrogate and actually go after her for the other money. They probably wouldn't over $500 or $300, but they do have that right, okay? All right, any questions, sir? Ma'am, any other questions?
Getting out of budget.
No, Your Honor.
All right, best of luck to you. Thank you. Daniel Van Kusick, 25T646-368 A and B and C. All right, Mr. Kusick, come on up to the podium. Tell me your name.
Daniel Van Kusick.
You're charged with open intoxicant, possession of drug paraphernalia, and protective equipment. You have the right to a lawyer. If you want one, I'll give you one. You want a lawyer?
Yeah, I guess.
Okay. We'll give you a lawyer. Sir, in the front row, what's your name? Go out in the hallway, Mr. Kusick, and I'm gonna have them bring the file out, okay?
Okay.
Sir, what's your name? What are you?
Speeding ticket, what's your last speed?
All right. Come on up here, Brian Thomas Davis, 25F244508. Lisa, we don't have a officer here. This should be Officer Hunter from Flat Rock.
Never checked them.
Not on Zoom.
Your name, sir?
Brian Davis.
All right, we gave him 15 minutes. It's 9:50. Case dismissed, okay?
Thank you.
You're all set. I wish you well. Good luck. You too. Cherie Nicole Bowman, 25W839397. Officer Perry here, Lisa.
He doesn't check on me.
Not on Zoom.
Your name?
Cherie Nicole Bowman.
Case dismissed. I gave them 15 minutes. You're all set. I wish you well. Good luck.
All right, let's change things up a little bit in our continued efforts to bring you 9 to 11% more Judge Boyd. Let's go to Texas.
Could I see, let me see what I have.
Have this from Sean.
Thank you. Thank you. All right. Who is the person on this?
Ashley Jones for the state, Your Honor.
All right, the court is calling 2024 CR 0129991W State versus Kiska Stewart. Could I have parties announced?
Ashley Jones for the state. Lindsay Shaw for Ms. Stewart.
And are you Ms. Stewart?
I am.
All right, we are here. Defense has filed a motion to terminate community supervision. According to this, the defendant has been placed on community supervision since December 19th, 2024, and it was for a period of 18 months. State, are you in agreement?
We are not, Your Honor, just based on the offense and the amount of time.
All right.
Yes, Judge. So this was a case, it's out of your court, but it was reduced to a misdemeanor. She was placed on deferred adjudication for 18 months. So as of today, she's been on nearly 10 months. Even since the supplemental report that you're looking at was completed, she has completed her community service hours. I provided the state a copy of her donation that she made to the Texas Advocacy Project for $309. She's completed her BIP. She has now completed her community service. As you can see, there's been no concerns of her violating any no contact or no harmful or injurious contact orders. She's up to date on her fees. We're asking the court, she has a young child and she's trying to go to school, cosmetology school. And since she has been on more than half of the term, we're asking the court to consider our request for early termination.
All right, this is what I can tell you. I will strongly consider terminating you on December, because December, that will put you at a year. And what I would like is I would like the complainant to be contacted, to be notified. If you have no violations and everything is fine, December, I will terminate her.
Could I?
Sure.
So if this, not only the BIP, I've also completed FENT program through the Peace Initiative, as well as the fatherhood campaign. Being able to get off early would give me the opportunity to renew my Texas insurance license, my health and life insurance. With Medicare coming up, that is a huge opportunity, not only for me, but for my son to be able to provide for him. Open enrollment ends December. So if I could get that license.
When you say it ends December, what date does it end in December?
So it starts October 15th and I believe it ends December 1st. So there's that 2-month period, or and maybe the 31st. But there's a.
All right, if somebody bring me proof that it ends at the beginning of December, because I'm not sure if it ends at the beginning of December. If y'all bring me proof of that, then I will consider early termination in November. But what I need is this is what I want you to take away from today. If there are no violations, state, you're going to have to reach out to the complainant and let them know that in November, if there are no violations, and if there's proof that early enrollment ends December 1st, then she's going to be terminated in November.
Yes, Your Honor.
If early enrollment doesn't end December 1st, if it's at the end of December 19th, if that's during the week, she's going to be terminated if there are no violations.
Yes, sir. Is that it? Okay, Judge, so will I need to file another motion or the court will terminate?
No, it will be done automatically.
Okay.
So probate, the only thing probation will need to provide to me in November, Ms. Abrams, is that there have been no violations. You won't even need to appear. The state will have plenty of time to have contacted the complainant to let them know that your probation will be terminated.
Can I? Sorry. I will also say with this, it is my son's father and we're also going through a custody battle right now. So with warning him, this might be ammunition to,
No, here's the thing. Let me just tell you. I understand. I've done CPS cases. I've done family violence cases. I understand when there are custody issues. This is what I'm telling you. If there are no violations, you're going to be terminated. The only issue with the court now is like the length of time. And I do realize that cases don't come to felony court as misdemeanors. I only handle felonies. So this tells me that this case was something else, and then it was pled down maybe to a misdemeanor. So what I'm telling you is, if there are no violations, no report from probation that there are any issues, your attorney won't have to come in and file a new motion. You won't have to come in. Probation will submit to me the early termination and I will sign it. And they're going to have to reach out to the complainant, because anytime I do early termination, whatever the termination it is, even if it's a theft case, I let the complainant know. I don't. I want the complainant to know so there won't be any issues if somebody sees someone. Because then that sometimes will result in new cases being filed, and I don't want that to happen. Okay.
Judge, can I have a date, November?
Let me look at the calendar here. Let's do, Norma, what date do you want in November? We can do the middle of November. Of course, I want it before Thanksgiving. All right, November 17th. And then if you want to stop in, Lindsay, you can stop in, but Ms. Abrams will give it to me and I will sign it if there are no violations.
Yes.
So whether it's signed or not is 100% dependent upon you. If there are no violations, and by no violations, I mean no positive UAs without prescription. If there's a no contact order, then no contact. If there's a no harmful or injurious order, no harmful or injurious order. No picking up any new cases. And then you won't have to come in on that day unless your attorney wants you in that day.
Yes, Judge.
All right, is there anything else?
Yes, no, ma'am. Thank you.
And it's in my notes, so I know what I said, but my mind is a steel trap, so I'll remember it anyway.
Thank you, Judge.
All right, thank you.
Thank you.
Yes.
Okie dokie. Let's go spend some more time with this Judge Pope guy.
Hey. Thank you. May I swear you in, please, sir? You solemnly swear or affirm that you will accurately and truthfully interpret the remarks made by the parties in this matter now pending before the court to the best of your ability.
Yes, I do, Your Honor.
Thank you, sir.
Kwanza
Mr. Matawa, good morning.
Jambo, Mr. Mutara.
Mr. Matawa, can you hear us okay?
Mr. Mutawa, unatusikiliza?
May you knock on the door and tell them to unmute you?
Yagonga mlango alafu wakutoe kwa mute.
Sawa.
Yes. Unatusikilia?
Ndio, nawafuata vizuri.
Yes, sema majina.
Naitwa kwa jina la Makano Mtatwa.
Makano Mtatwa.
Thank you. These matters are both scheduled for a pre-trial conference this morning.
Nasema tulikuja hapa kwamba tuangalie hizi habari hapa mkutano wake.
And what is the status of the case, counsel?
Yaani wanauliza wanashariwa haya mmepanga nini?
Mr. Mutatwa completed an alcohol assessment, and I sent the report to Ms. Woods We are waiting for, we'll be in the middle of negotiations to see how we can resolve both matters.
Nasema kwamba yani Mr. Mtara alimaliza kwamba yani ile mitihani midogo aliulizwa, alafu nilituma hiyo kwamba hizo habari za majibu kwa Miss Wood kwamba yani angalie, tunataka tuangalie kwamba yani tutazimaliza namna gani.
So I am requesting an adjournment and an opportunity to address bond.
Nasema kwamba yani napenda kwamba tupate muda ya kuenda mbele kidogo, na pia nizungumze habari kama yani yeye anaweza toka namna gani.
Bolton, how much of a adjournment are you requesting?
Nataka kwamba muda kama ngapi?
Just a couple weeks should be enough for me.
Nasema kama ni wiki fulani tu itakuwa kwa mizuri kwangu mimi.
Ms. Woods, any objection?
Kuna
No,
shida
Judge.
yoyote? Nasema hapana.
However, if I guess I may change that request depending on your decision on bond.
Nasema kwamba nilikuwa napenda kwamba nizungumze habari yani utoleo wake kwamba ni jukumu zile zitamfuatilia.
I have a note here that the gentleman is serving a sentence right now in the Washington County Jail with an out date of October 29th.
Nasema kwamba ninaonyesha hapa kwamba ni yeye anahitajiwa kwamba ni kule kwa kwamba tarehe 29 anaenda kuhojiwa kwamba ni kwa kesi nyingine.
Ms. Bolton, is that still true?
Hayo ni ukweli, wanaulizwa mwanasheria mwingine.
No, he is set to be released on September 30th.
Nasema kwamba ionyeshwe kwamba alikuwa anatakikana atoke kwamba ni mwezi wa 9 tarehe 13.
What did you want to tell us about sentencing? Bond, Ms. Moulton.
Yani unataka utuambie kwamba sasa akitoka atafuatiliwa nini na nini?
Mr. Mutatwa is in custody because he violated probation on another case by picking up these new cases, and he was sentenced to 180 days.
Nasema kwamba Mr. Mtata kwamba yeye alivunja sheria akiwa kwamba yeye anafuatiliwa na serikali, akachukua hii habari tena ya ulevi kwamba ndio kwa sababu wakamtuma gerezani mpaka siku 118.
Again, he is set to be released on September 30th. Since he's been in custody, he's completed a substance use class with Dawn Farm and also completed an alcohol assessment with CMH.
Nasema kwamba tangu afungwe kwamba yeye ufunguliwa wake utakuwa kwa mwezi huu, akienda tarehe 13 atoke gerezani, na akiwa hapo ndani alichukuliwa habari za vipimo vya ulevi, alisomeshwa masomo kidogo kuhusiana na ulevi, maana yake zote alimaliza hayo masomo yake.
He is the sole provider of his family. He has a wife and 5 children. Unfortunately, he's lost his job since he's been in custody.
Nasema kwamba yeye ndio muongozi wa familia na akona watoto 5, kwamba alipoteza kazi yake tangu afungwe.
He does have low cash bonds in these cases. I believe he was in order to get jail credit. I'm not sure if Ms. Woods have any objections to that, but we are asking for a personal bond.
Nasema kwamba yeye sahi hana faranga zozote, hata kusema kwamba umwekee kwamba kutoka kwake alipe 500, 200, hana kitu chochote. Kama mnaweza muacha bila kulipa kitu chochote.
Ms. Woods, do the people take a position on bond?
Kwamba
Yes, Judge.
kwamba anaulizwa kwamba na wewe unachukua hiyo.
Judge, if you are to modify his bond conditions, we would ask the court to make sure he's released with an alcohol tether.
Nasema kwamba kama unataka ubadilishe kwamba hiyo mipango yake ya kutoka, nataka atoke akiwa kwamba amefungwa mchuma kama halipi kitu chochote.
The defendant has a prior OWI from 2022.
Kwamba ana shida ya kulevi mwaka 2022.
And he also has these 2 cases which are OWIs.
Na pia kwamba ana hiyo shida ya ulevi tena kwa hizi 2 tena.
So we believe that the tether is necessary because there is some substance abuse issues going on.
Nasema kwamba lazima kwamba anafungwa mchuma kwa sababu ya hii ulevi unaendelea.
It's already a condition of his release that he be released to a tether with community corrections supervision.
Anasema kwamba ni anaweza tolewa hapo afungwe mchuma, na pia kwamba ni wale watu wa serikali wamfuatilie.
The court has adjourned the pretrial in this case to October 9, 2025 at 9 a.m.
Sema kwamba ni mahakamani walipeleka hii habari kwamba ni mwezi wa 10 tarehe 9 saa 3 kamili.
In each case, the court will modify the bond to a $5,000 personal recognizance bond.
Yaani kwamba ni kwa hii kesi kwamba ni mkatiba amekatia kila mmoja 5,000 kwamba ni, lakini ulipi kitu chochote, bora ukuje kwa mahakamani hapo.
Conditions of all bonds, sir, include that you not violate any criminal law.
Nasema kwamba ni kila kitu inaongezeka, ni kama nini, usivunje sheria tena.
You appear in court when directed to do so.
Unatakikana ukuje kwa mahakama mida ile wanakupangia la ndevu.
You are not permitted to leave the state of Michigan without gaining prior court approval.
Hujakubaliwa utoke kwa state ya Michigan mpaka upate karatasi kutoka kwa koti.
You are not to purchase, possess, consume alcohol or any illegal drug.
Utaikane ununue kitu chochote cha ulevi, bangi, ulevi wowote.
You are to be fitted with an alcohol tether prior to release.
Nasema kwamba ni kama unatakikana utoke gerezani kama leo au kesho, ni lazima ufungue huo mchuma.
And report to the Community Corrections Office for supervision within 24 hours of your release.
Yaani ukitoka leo kwamba unatakikana uende ukaangalia wale watu wa community correction kwamba ni wakufuatilie.
Now, Community Corrections is located right across from the jail building.
Yaani hao watu nao pia ukitoka gerezani ya fungwa, yani mbele yake tu ni hao watu, yani community corrections wako hapo.
Depending upon the time you get released, you can go there the very day you're released.
Nasema kwamba ni muda wote ukitoka hapo gerezani, wewe enda tu hapo moja kwa moja.
If when you're released, the office is closed, you're to report the very next morning.
Nasema kama ni ulitoka hapo tumechelewa na ofisi imefungwa, yani siku ya pili fika hapo.
Mr. Matawa, do you understand all that, sir?
Mr. Mtawa, umeelewa haya nimeyasema?
Ndio.
Yes.
Okay. Be aware, of course, that any violations may result in your immediate arrest and being incarcerated again.
Nasema kwamba ni ukitokezea yoyote ulevi yoyote, jua utafungwa hapo moja kwa moja.
Nashukuru.
Anything else from the attorneys?
Yeah, kuna nini nyingine mnaongeza wanasheria?
Nothing from the people.
Yaani watu wa serikali hawana kitu chochote cha kuongeza,
Not for me, thank you.
na mwanasheria wako anasema hana kitu chochote. Asante.
That concludes the hearing. Mr. Matatwa, good luck to you, sir.
Anasema hapo ndio tumemalizia huu mkutano wa leo. Haya, safari njema unaweza kutoa leo.
Nashukuru sana.
I appreciate so much.
All right.
Kwa heri.
Okay, bye.
I leave you on.
Thank you, interpreter.
Yep.
Bye.
Alrighty, let's go back to Judge Boyd as another contestant approaches.
Good morning, Judge.
Good morning. How's it going?
Good, and you, Judge?
Oh, I'm doing great. All right, the court is calling 2024 CR 6325 State versus Luis Alec Martinez. Can I have parties announced for the record?
Lauren Espinoza for the state.
Joseph Davidson for Luis Alec Martinez.
And are you Luis Alec Martinez? We have an interpreter. If you could raise your right hand. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand, state your name for the record.
Joseph Chavez, license number 2203.
All right, so we are here for sentencing, and there was also an issue with regards to restitution. The defendant agreed that he owed a restitution amount to Juvenile Flores in the amount of $17,240.80. The restitution amount to Jesus Zuazua was previously not agreed to. It's the court's understanding that agreement has been reached in the amount that's owed for restitution to Jesus Zuazua. Is that correct?
Yes, Your Honor.
State, is that correct?
Yes, Your Honor.
And what is that amount?
That amount is going to be $7,300.
All right. And the person before me, is that Jesus Zuazua?
That is Mr. Jesus Swaswa.
Swaswa.
Yes, ma'am.
See, I'm saying Zuazua because
I said Zua.
you're supposed to help me. I'm trying to learn. All right. Could you raise your right hand for me, please, sir? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I swear.
All right, you can lower your hand if you'll state your name for the record.
Jesus Guadalupe Suazua Maltos. Jesus Guadalupe Suazua Maltos.
And I'm sorry, the last name?
Suazua. Jesus Suazua.
But he had said something.
Maltos. Maltos.
Maltos, all right. So both parties said that they're in agreement with a restitution amount of $7,300. Do you agree that that is the restitution amount that is owed to you?
Yes.
All right, any other questions?
No questions.
Nothing from the state.
All right, thank you. You may be excused. And I don't know if they'll continue to need you for the sentencing,
Not for my clients.
but I mean for Mr.
Suazua Maltos. Do you
Yeah.
want him to hear the sentence?
Yeah, probably.
Okay, then I'll stay.
Would you like that state? Okay,
Okay.
all
You
right.
want to stay here?
You can
I
state
can
this.
sit back there.
All right, thank you.
Last one.
All right, so now with regards to restitution, the court's issue is, has any of this been paid?
There were upfront restitutions made in the amount of $300, which were money orders cleared. Aside from that, there's no, that was previously made prior to signing the plea paperwork. Since then, my client's been trying to save money, and one potential, well, not a potential, but one issue is that he was, I believe, and he believes he was wrongfully discharged from his
All
position.
right, just 1 second. Everyone, we are on the record. Whisper.
I believe he was wrongfully discharged from his position as a contractor, where the general contractor may have fired him. And he's disputing money that's owed to him. He was not able to get money from his employer, so he could not pay his contractors. And he has a civil suit that he's hoping to recover some damages that could apply towards any restitution. In the meantime, if I may call him to.
All right, so just 1 second. So you're saying so far of the restitution amount that he owes, how much is he paid?
$300 to Juvenile Flores and $300 to Jesus Zuazua.
So he's paid $600 total.
Yes, technically there were other payments made to 2 additional people. However, they did not appear for the restitution was waived for those 2. So he had paid $1,200.
All right, so that leaves a balance to the remaining 2 complainants of $23,940.30. So the question becomes, how is he ever going to pay this?
He's employed, he's working, he has a job, he plans on making monthly payments. And if I may make.
Yes. Call your witness.
If I may call my client, Mr. Martinez, to the stand.
Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand, state your name for the record.
Luis Alec Martinez. May I inquire?
Yes.
Mr. Martinez, are you currently employed?
Yes.
Do you have the ability to make some restitution payments?
Yes.
the time period to make these payments, so they're not drawn out within 30 days. Are you able to make a lump sum payment to two individuals, Mr. Flores and Mr. Zua, and in what amount to each one within 30 days?
Within 30 days, I could do 1,000, and then I'd be comfortable doing $500 to $600 a month.
All right, so are you going to be able to pay? Well, when will you say that you're able to pay the $1,000?
It's about 30 days, if October 31st, end of October.
Yeah.
If there's the last Friday, perhaps in October.
What date is that?
That's actually Halloween. The courthouse should be open October 31st.
So are you able to make a payment of $1,000 October 31st?
Yes, ma'am.
All right, and then after that payment, how much are you going to be able to pay per month?
I'd be comfortable with $500 or $600 a month.
And would that be, just so that it's not a overly burden, I want to make sure I understand. Is that, if it's 500 a month, is that 250 and 250? Or is it 500, 500? It's 500 total, correct?
Yeah, it'd be 500 total, because I think doing the calcs, I think that kind of works out for a 4 or 5 year period, I think. And then obviously if I win when I collect the damages from the suit, I would pay that off entirely.
And if you did come across additional income or had supplemental income, you would be able to pay it off sooner?
Yes.
And you understand that if, aside from the regular conditions of probation, aside from other reporting and classes you would have to do community service, if you don't make payments, you understand the court could revoke your supervision, and you have a motion to revoke probation filed if you don't make these payments?
Yeah. Yes.
All right, any questions?
None from the state, Your Honor.
All right, Ms. Abrams, are you ready?
Is this on cost?
Yes.
Right.
All right, this is what the court is going to do. The court is going to sentence you to 5 years deferred adjudication. The amount of restitution owed to Mr. Flores was $17,240.80. The amount owed to Jesus Swaswa is $7,300. And the last name for that complainant is Zuzua. First name, Jesus. The complainant who's owed approximately $17,240.80. The first name is Juvenal. Last name, Flores. The defense has told me that the defendant has already made some payment amounts. So the total balance that will be due is $23,940.80. The defendant agrees to make a payment of $1,000 no later than October 31st, 2025. That $1,000 is to be split evenly between both complainants. Thereafter, the defendant will make a payment of $500 per month at the end of each month. And that is to be split evenly between both complainants. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors, field visits 1 time per month for 3 months. There is to be no contact with Jesus Ramirez, Jacob Soto, Jesus
Swaswa.
Juvenal Flores, There's to be 100 hours of community service restitution that will be deemed satisfied upon the life skills course or some type of business course. I'm sorry, not the life skills course or business course, but a money management course. Probation, is there anything else?
I just need a couple of things clarified. Can you spell Mr. Flores' name again?
Juv as in Victor, EN as in Nancy, AL. Last name Flores.
Okay, and then there were numbers given. So I need clarification on what's due after he's already paid what he's paid.
All right. So
I know $23,940.80, but how much to Mr. Flores and how much to Mr. Lockdown?
all right. So on Mr. Flores, the total amount due was $17,240.80. It's the court's understanding he's already paid $300 towards that.
Correct.
So there will be $300 minus the 17,000.
Your Honor, my understanding was that was the amount after the 300 paid, because the initial amount was,
I may have misspoken. I'm sorry.
yeah, that is after the 300 already.
All right, so correction, probation, the amount due to Mr. Flores is $17,240.80. And that includes the $300 deducted. The amount due to Mr. Swaswa, I'm gonna get it right. The amount due to Mr. Swaswa after the $300 has already been paid is $7,300.
Yeah.
We agreed to 7,300. He's already paid it. If our understanding is that we agreed to 7,300, but he's already paid 300. We're asking credit for the $300.
All right, so the amount then due him is $7,000. Is there anything else? Is there anything else you need from the court to be successful?
Just if we could get probation moved to Tarrant County where I currently reside.
All right, and there's to be a transfer to Tarrant County.
Additionally, with the construction business he has, in the event that he has to do job work.
All right,
make
and
it
the
live-
defendant is allowed to work throughout Texas.
Thank you, Judge. And if he has to travel out of state, would you allow him to notify his probation officer with some type of pre-approval as long as he gives them sufficient
Yes,
notice? Okay.
yes.
Thank you.
All right, is there anything else?
Nothing from the state.
I don't believe there was a fine. I may, unless I missed it out.
There's a zero fine.
Thank you, Judge. Nothing further.
All right. Mr. Martinez, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Is this one? Yes.
And because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you. Just remain in the courtroom and probation will go over conditions with you.
Thank you, Judge.
Yes.
All right, let's rotate back up to Judge Simpson so he can very quickly mute on me again.
Treatment. If you prepare the order, I'll sign that.
Thank you, Your Honor.
All right. Thank you. Court does call the case of the People versus Brandon Kelly. Any luck with Mr. Kelly? All right.
Your Honor, Michael Gaddy, Assistant Public Defender, on behalf of Mr. Kelly. I see this Zoom screen. I don't see Mr. Kelly.
Mr. Kelly? Oh, they're taking. Got it. Mr. Kelly, can you state your name?
Brandon Kelly.
Thank you. What are we doing?
Your Honor, I've had a chance to speak with the prosecutor. I spoke with Mr. Kelly yesterday. I was going to report to him this morning, but he wasn't able to be brought up. I was able to meet with him yesterday. I'd ask the court, I think we're kind of at an either or set or waive situation here. I would ask the court to adjourn this 1 week so I can have that conversation with you, Judge.
My next available date's the 30th. Probable cause conference will be set for September 30th, 2025, 9 a.m.
Thank you, Judge. May I approach with the green sheet?
Yes, bond continue.
I'll come and visit you, Mr. Kelly. That was 9:30, correct? Judge?
Yes. Court calls case People versus Annie Oglesby.
Tina Sachs on behalf of Annie Oglesby.
Your name, ma'am?
Annie Oglesby.
Thank you.
Your Honor, I'm requesting a preliminary exam date. If you remember, Your Honor, there's another case that was set on the 30th for a preliminary exam, if possible.
Before who?
I do not know. I was on Zoom.
So she has another case set on the 30th?
Yes, and it's actually a companion case.
Got it. Miss Oglesby has another, Miss Oglesby has another case on the 30th?
Yes.
Who is that before? Okay.
I'm sorry, who is it before?
So you'll be ready on that? Would
Yes, Your
people have their witnesses available on the 30th?
We'll try.
All right.
Thank you.
Preliminary examination in person will be set September 30th, 2025 at 12 noon. That is before me.
And Your Honor, may I make a bond argument?
You may.
I'm still waiting.
Your Honor.
Yes.
Your Honor, at our last hearing, I made this argument that Ms. Oglesby now will be staying locally, so she will be able to test. She's been incarcerated since the night of the event reincarcerated after not testing. But now that we've confirmed that she will be staying in Pittsfield Township, she will be able to test with community corrections. And she has already started programming while here. So there is a plan in place.
I'm going to deny the request. I don't need a response. Understanding that she's got a preliminary examination coming up in 5 days, and I'll reconsider any request after that point.
Okay, thank you.
Thank you. Bond will continue. Court calls the case of the People versus Louis Atkins.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Atkins. Will you state your name for the record?
Larry Atkins. Larry, okay.
Your Honor, we are asking
Just
for.
put a Y. No, I know you, it's not your fault. All right, go.
Your Honor, we're asking for an adjournment. We are completing some mitigation information that we'd like to propose to the prosecutor's office, if we could have some time to complete that.
Probable cause conference, October 16th. Will that be enough for you?
I hope so.
All right, October 16th, 2025, 9 a.m. bond continue. Thank you. Larry. Court calls the case People versus Johnny Bankhead Williams.
Alexander on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Bankhead Williams. Say your name for the record.
Johnny Bankhead Williams.
Thank you. Your Honor, we are asking for an adjournment. We are missing video discovery still.
Got it. Probable cause conference, October 9th, 2025, 9 a.m. bond continue.
Thank you.
Thank you.
Court calls case People versus Amanda Corwin.
Christina Costantino appearing on behalf of Ms. Corwin, who's coming up to the podium now, Judge.
All right.
Amanda, can you state your name for the court? Amanda Corwin.
Thank you.
Judge, this is the date and time set for PCC. I was just recently retained by Ms. Corwin, and I will need some time to obtain discovery and review it with my client. So we would be asking for an adjournment of the PCC. And I do have a green sheet.
All right. Without objection, probable cause, October 16th, 2025, 9 a.m.
Thank you, Judge.
Bond continued. Thank you.
Thank you very much.
Court calls case People versus Roderick Bates.
The public defender, can I be carried back in here? On behalf of Mr. Roderick Bates, who is approaching. Mr. Bates, state your name for the record, please.
Roderick Bates. Thank you.
Your Honor, we would like to set this matter for a preliminary examination.
Discovery is complete.
To my knowledge, Judge, yes.
Have their witnesses available on the 7th.
And Judge, if I can address bond briefly, please.
Preliminary examination in person will be set October 7th, 2025, 9 a.m. That is before Judge Fresh Hour. Yes, as to bond.
As to bond, Judge, Mr. Bates is currently in custody because he failed to appear for his last probable cause conference. And prior to this, he had been coming to court and he had not missed a date. I thought I had the date of his last hearing written down. 2 hearings ago, he came to court late. And his case was called and then a bench warrant was issued. We submitted a request for a bench warrant recall. However, once that recall was granted, I don't think that Mr. Bates received the next date for his hearing, which subsequently caused him to miss the last probable cause conference date. I spoke with him and I put on my Judge Simpson hat.
My phone was off.
Pardon? We did not
My
have.
cell phone was off, and I didn't get an email or nothing.
So we did not have any contact information for him. Well, any working information at the time.
Go ahead. I'm hearing your argument.
So, Your Honor, I put on my Judge Simpson hat and I asked myself.
Wow. Wow, you have one?
I borrowed it from Mr. Brown.
Oh,
I said, what would Judge Simpson?
He has one. What would Judge Simpson?
That's correct. Yes.
Yeah. So we have bracelets for sale. Anyway, go ahead.
So I asked my client, Your Honor, all of the questions that I could anticipate the court asking him. He does take responsibility.
No, I got more.
I'm sure.
Okay.
We can never, we'll never meet that standard, but I tried my best, Your Honor. And he took responsibility. He said that he tried to contact our office. He was contacting the attorney who he had worked with originally. Obviously, that was not the attorney on the case. They did not receive that information. However, I informed him that our number is, I gave him our number. I told him that any attorney in our office would have been able to help him with that information. He does now understand. He doesn't have a criminal history to my knowledge, Your Honor. And the only reason that he's got this bench warrant was because we were not able to get in contact with him. Prior to this, he had been to all of his hearings until somehow that mix-up happened.
I have 2 questions.
Yes, Your Honor.
First question is that hat that Mr. Brown let you use?
Right.
Did it have a block M on it or a Maryland hat?
Maryland.
All right. So just check it. You had to check, really?
No, I knew it.
Okay. The other thing is that I'm trying to figure out. When did you submit the request?
I believe it was submitted the next day or that day. He indicates that he came to court. They had informed him that the bench warrant had already been issued, that he had missed his court date. And then that request was submitted at that time. Let me grab it.
Do we see that?
Oh, it's the 21st.
Was it on the 21st?
I was supposed to be here. I was an hour late for it.
I showed the protocol.
So from the 22nd, it was canceled that same day.
Yeah.
Because of that, and then it was reset to August 7th.
Yes.
And
Yeah,
then
no,
he
no,
didn't
no, no.
appear on August
He
7th.
did not appear on August 7th, Your Honor.
Response from the people.
Up to the special report, Secretary, I think you would need to explain, for, the hearing, what had occurred, so, I will leave it up to the
She
special.
was just bouncing that off to see, well, we think this will work. Thank you, Ms. Douglas. This previous bond was $25,000 personal charges. Okay. Given all of that, I will reinstate defendant's bond at a $25,000 personal recognizance bond so that he can be released. So I'll grant the motion. You understand that, sir?
Yes, thank you, Your Honor.
And Your Honor,
When are
can
you
we get
supposed
the,
to come back to court?
Oh, I will show up every time.
When? Don't give him a hint.
Yes, Judge.
You said the 7th, right?
I dare you not to show up if I'm letting you out. October 7th, 9 a.m.
Thank you so much, Your Honor.
Thank you, Your Honor.
You're welcome. Court calls the case, People versus Matthew Brown.
Again, on behalf of the people.
Christina Costantino appearing on behalf of Mr. Brown, who is present via Zoom. Mr. Brown, can you please unmute and state your name for the court?
Yeah, Matthew Tyler Brown.
Thank you.
Judge, this is the date and time set for PCC. There is still some outstanding discovery. We have had some discussions about that discovery and about specifically what is missing and our plan for getting me that discovery. So given that, we would be asking for an adjournment of the PCC so that I can ensure discovery is complete.
All right. Would the 9th be enough time for you to get the information?
I would think so. Would the 9th be enough time?
I hope so. What she's looking for is not in our possession, so we need to request it from the agency.
All right. I'll give another week on that. October 16th, he's not in custody. So October 16th, 2045, 9 a.m.
Thank you.
Thank you, Judge.
Thank you. Bond continue.
Thank you.
Thank you, sir.
Yep.
Court calls the case, People versus Eric Brackman.
Trevor Maple with the people, Your Honor.
Good morning, Your Honor. Assistant Plug Senator Davia Lieb on behalf of Mr. Brackman, who is standing to my right. And Your Honor, we are waiving today. Mr. Brackman, if you could sign.
Your name, sir?
Eric Brackman.
Thank you.
And Your Honor, we are waiving with an agreement that they will not be adding a habitual.
Is that a correct statement from the people?
Your Honor, I didn't hear that last statement.
We are waiving with an agreement you will not be adding the habitual.
That's true. I do believe that the defendant needs to be arraigned on the amended.
That is true.
On the added count two.
As well as the amended count 1, Your Honor.
Okay. Have you seen that?
I have, and I've reviewed it with Mr.
Wait,
Brackman, and we
review
do
that.
Yes, Your Honor.
And how does your client plead to?
We stand muted this time.
I'll indicate defendant arraigned none. Thank you.
Thank you, Your Honor, and we will not be adding the habitual.
Sir, you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, Your Honor.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
Your Honor, we acknowledge receipt of the information, waive formal reading, and stand mute.
Defendant every waive formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
October 9th at 1:30, Judge Slay.
October 9th, 2025, 1:30 before Judge Slay.
Thank you, Your Honor.
Bond will continue. Thank you. Okay. Court does call the case of the people versus Malachi Harris, aka Malachi.
Christina Costantino on behalf of Malachi Harris. Mr. Harris, can you please state your name for the court?
Malachi Harris.
I told you that's what.
Hands out of your pocket. Yep, you're good.
All right. What are we doing?
Your Honor, we have reached a resolution in the case, but we do need a bit more time just to facilitate some plea paperwork.
Okay.
So we would be asking for just a brief adjournment of the PCC to accomplish that.
October 9th, 2025, 9 a.m. bond.
Thank you.
All right. Thank you.
All right, let's head back to Judge Boyd because I don't think we've reached our 9 to 11% more yet for today.
Oh, wow. Court,
Nothing exciting.
okay. Court is calling 2025 CR 006-994, State versus Lamar Simmons. Can I have parties announced?
For the state.
The attorney of record is Joanne De Hoyos. Joseph Stateson covering for Joanne De Hoyos. She is on vacation.
All right. Do you have any objections to this attorney standing in for Joanne De Hoyos? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor. And I know that we've been here a few times, some back and forth negotiations. And I just want to make sure that Mr. Simmons has received an offer that they've accepted truly and wants to go forward with this plea. That's correct, Mr. Simmons?
Yes.
All right. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it, sign it in all the appropriate places?
Yes.
You're charged with an unauthorized use of a vehicle. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you any defenses to this offense?
He has. We've discussed it and we feel comfortable going forward today.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Simmons, has anyone threatened you, coerced you, placed you in fear, or forced you to enter this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yeah.
Did you understand if you're not a U.S. citizen, by entering this plea, you can be deported, not allowed to re-enter the United States, and denied naturalization?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 60 days in the Bexar County Jail under 1244. There's a $700 fine and no applications. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, Your Honor. If I may add something at the appropriate time.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
None.
Then to the offense as charged, how do you plead?
Guilty.
State
No
any,
contest.
Your Honor, I'm sorry.
Contest.
Yes, no contest, Your Honor.
all right, state any evidence?
Yes, Your Honor. Offer States Exhibit 1 and all attachments.
No objection.
Did you, state, you may be excused.
Okay.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments, and the court will review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, we wish to waive PSI.
Anything you wish to say on behalf of your client?
Your Honor, I would ask that you follow the agreement of Mr. Simmons did indicate that he wanted the credit for time served. I know that it's very customary for judges to order that. I was hoping that you could order it and have it reflected on the plea bargain page or on the judgment. He has 10 actual days, it's credit for all 10 days. And I told him that you're not authorized to give 2-for-1 credit. I know that the jail has their own policy. That's up to the jail for any calculations. So we ask that you follow the 60-day agreements. Don't go outside that, and all credit for time served and time money run concurrence.
All right, the court will, as previously stated, the court is going to follow your agreement. The court will sentence you to 60 days in the Bexar County Jail under 1244. There is a $700 fine, time and money to run concurrent, and court will give you credit for any time served. And so if you have 10 days credit, you'll receive 10 days credit. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yeah.
All right, because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Mhm.
All right, so what I can tell, we're off the record. So what I can tell you is the clerks will put into the system the number of days that you're to receive credit for. And as your attorney told you, I'm not responsible, or I can't make the sheriff's department give you 2-for-1 or 3-for-1. That's completely up to them. What I can tell you is, in subtracting the 10 days that you've already served, the most you will serve is 50 days. Do you understand?
Yeah, so the 2-for-1. Right?
Well, the jail will calculate that.
What I can tell you is normally at the jail, if you're in general population and you do not cause any issues, you automatically receive 2 days for every day you serve. If you become a trustee, then you receive 3 days for every day that you serve.
Good. Thank you.
Thank you, Judge.
Thank you. All right, anyone else who's ready? All right, Ashley Medina. Oh, they're still talking. What else? All right, thank you.
Next, we have
All right, well, she searches out another contestant. Let's go spend some time with our silly old friends in Louisiana.
47. My name is Carolyn Stapleton, and I will be the chairman today. My colleagues on the panel are joining us by Zoom, Jerry Ledoux and Mr. Steve Prater. Is there staff in your location, sir, where you're at? Mr. Jefferson, you're on mute. Mr. Jefferson, can you hear us or speak?
I'd like you to, let me.
Okay.
Yes, ma'am. You hear them?
Yes, yes.
No, they hear you?
Well, thanks with staff around.
They hear you?
Yes, ma'am.
Yes, and we're today, our remote location is LaSalle Correctional Center. And staff, will you please introduce yourself for the record, please?
Let me go get them. They need you in here. You need you to state yourself for the record.
Hello?
Yes, ma'am. Would you give us your name for the, please?
I'm Officer Barbara.
Okay, thank you, officer.
Okay, you ready for him again?
Yes, ma'am. Thank you.
Okay, you're welcome.
Okay. Mr. Jefferson, go ahead and give your name again and DOC number for the record, please.
Rynell Jefferson, RYNELL Jefferson, JEFFERSON, 605401.
Okay, thank you. Do you have a questionnaire in front of you?
Yes, ma'am.
Okay. And so according to the questionnaire, you do not qualify for appointed counsel. You're aware of that, sir?
Yes, ma'am.
Okay, thank you very much. Okay, at this time, your case has been assigned to Mr. Steve Prater. He is going to ask you questions about your violations, and he will explain the everything to you. And also, he's going to allow your supporters to speak also. So, Mr. Prater, I'm turning the hearing over to you. Must be on mute.
Okay, Madam Chairman, let's hear from the supporters because I don't have their names or anything.
We'll do that right now. Okay, you have support, and it's, I believe it's Quanteria Allen. She's your girlfriend on Zoom. And then also it will be Chancey Jefferson, your sister on Zoom. So Miss Allen, would you please speak?
Okay, so how much for this? Well.
Hello, Miss Allen?
Yes, ma'am.
Okay, would you please tell us what you would like us to know?
Ronell did not commit the crime. I was with him the same night.
You're his girlfriend and you're saying he didn't commit the crime?
No, ma'am, he did not commit the crime.
You know, we have pictures of a black eye and a busted lip that they took that night, which you allowed them to take. How did you get that?
I'm not that girlfriend.
Oh, you're a different girlfriend. And so you're saying the other girlfriend?
The baby mama.
Oh, okay.
Yes.
All right. So you're saying he didn't, anything else you'd like to say?
No, ma'am.
Okay. So at this time, we will go to Chancey Jefferson, his sister. Are you Chancey? Hello? Are you Chancey Jefferson?
Yes, ma'am.
Okay, what would you like to tell the board?
Well, the baby mama was supposed to say it was supposed to be happening at my residence, which I didn't occur to see none of it.
You were there? You're saying you were there and
yes, ma'am.
And nothing
Yes,
happened?
ma'am, and he was home that whole night with Quantera.
Okay. Mr.
This is not the first time he did it.
Okay, Mr. Prater or Ms. Ledoux, do y'all have any questions of his supporters?
No, ma'am.
Okay, all right, well, thank you very much then. Okay, at this time, I'm going to turn the hearing over to Mr. Prater.
Mr. Jefferson, how are you today?
In my way, sir.
Okay. When you get out of jail, when you get on parole, you sign a list of things that you agree to. These are called conditions of parole.
Yes,
And according to your parole officer, there are 4 that you seem to have violating: 2, 4, 8, and 10. We'll go over those quickly. Number 2 says that you failed to report for the month of March 2025. Is that true or not? That you failed to report to your parole officer?
He had my number or whatever. I told him I didn't have a ride, so I didn't make it.
Did you talk to him?
Yes, sir.
You talked to him on the phone, told him you didn't have a ride, but is that right?
Yes, sir.
Okay. Well, let's move on. So you're saying you're not guilty of that?
Yes, sir. Well, I just didn't have a ride at that time. This a whole year and something I've been out. This is my first time missing. Not been able to see him.
All right. Condition 4, you were arrested on March of 2025, a few months ago, for battery of a dating partner, Destiny Daniel. And she had a swollen left eye and a busted lip, and she contends you held her down and punched her in the face.
I got found not guilty of that or whatever.
Well, that's not exactly what I have in the record. It says that you pled guilty in July of 2025 for disturbing the peace and got 90 days in jail.
But for being loud, like I have my witnesses saying that none of that happened. I just played after that. They just gave me that disturbing the peace for being loud.
For being
Just to get
loud,
out there.
but where were you loud?
I just played out to anything just to get it out the way. It never happened. I never did a batter or anything. I was with my girlfriend, Quinteria Allen, the whole day.
You weren't even there, right?
Yes, sir.
Okay, so you're saying you weren't there, but
I got
she came
found
up-
guilty for, I got found guilty for being loud for, that's it. They
But
never,
where were you? That's what I'm asking. At what location were you loud at?
my sister's house,
You weren't with Destiny when you were loud?
I wasn't with her at all, period. I never got found guilty of being with Destiny or hitting get Destiny at all.
So just so I have this right, you were charged with battery of a dating partner,
Yes, sir.
but they dropped that charge on a plea bargain
Yes, sir.
that you pled to disturbing the peace
For being loud.
for being loud somewhere else.
Yeah, they just wanted a conviction, I guess.
That I'm having trouble following that, but I don't think I'm going to go into a lot of detail about it. Okay, condition 8, you tested positive for THC. You know what THC is?
Marijuana.
Yes, sir. You tested positive for that. You were ordered to go to the Natchitoches Behavioral Center for some programming, and you failed to show that you had done that. Did you go to the Natchitoches Behavioral Center?
My parole officer, Paul McLaurin, said as long as I have my prescription, I didn't have to go.
Okay, where is your prescription? He said that you never showed up with that. You never showed him
It's
that
over there at the
card.
house in a car from Good Day Farms.
Okay, when did you get that prescription?
Like right after that.
Right after that.
They
Okay.
told me to come with my prescription.
Okay, well,
for
see,
anxiety.
that's a problem. You didn't have the prescription when you took the drug test.
No, sir.
Okay, and number 10, violation of condition number 10 says you owe $816 parole and probation fees. Is that correct?
I was enrolled in school. I was trying to get help paying in school.
So
And
you're
nobody helped me paying. Nobody helped me paying. I don't have a job. I was just going to school, barber
Okay.
school.
okay. So you admit that you owe the money, correct?
Yes, sir.
You admit that you tested positive for the drugs. Is that
Yes,
correct?
sir. Yes, sir.
You admit you did not have a card at the time that you took the drugs. Is that correct?
Yes, my parole officer told me as long as I have a prescription, I didn't have to go.
But didn't you tell me you got the prescription after you had taken the blood?
Yes, that's what he told me. All I need is a prescription. I didn't have to go.
Okay, but you didn't have it. Okay. All right. That's all the questions that I have.
Ms. Ledoux, do you have any questions?
I've fully read the report. I don't have any questions.
Okay, I don't have any questions either. So at this time, the panel is ready to vote.
Yes, ma'am.
Okay, we'll begin with the board member assigned to your case, which is Mr. Prater.
Mr. Jefferson, I believe that you are in violation of conditions 2, 4, 8, and 10, and because of that, I vote that you be revoked.
Ms. Ledoux?
I concur with my colleague. My vote is to revoke.
And I concur with my colleagues. My vote is to revoke today on the same conditions 2, 4, 8, and 10. That concludes our business today, and the time is 10 o'clock.
Denied.
So, real talk here, friends. I am shocked right now. Absolutely shocked that this guy had his parole revoked. I don't get it. It makes no sense to me whatsoever. And you need only go back to the supporting statements, the supporting witnesses that he had there. I mean, you had baby mama, and you had whoever the other one is, who I can't even remember, even though the testimony there was so incredibly moving and tight. You would think that I would remember it, but I just can't. But I know it was good. So, this board just disappoints me every single time. This guy should not have been revoked right there. Not given everything that we heard. I don't get it. Let me know what you think in the chat. I'm so shocked. Hashtag sarcasm. All right, let's go back to Judge Boyd. Let's make that happen.
Yes, Your Honor. State filed a motion to increase bond in each of the theft offenses in this court.
All right, could I see the motions? Are you ready to proceed on the motions, counsel?
Yes, Your Honor.
All right,
Do you need?
they should have them. If you have copies, I'll take them. Is there going to be any objection to the increase in bond?
Just some argument, Your Honor.
All right.
Here's two. Let me grab the last one. I just need another
Thank
hand.
you.
They're all, I'm so sorry. They're all the same.
All right, the court is calling 2025 CR 0000524, 2025 CR 0000525, 2025 CR 0025886, State versus Charles Mullinex. Could I have parties announced?
Lauren Espinoza for the state.
Victoria Cruz on behalf of Raymond Martinez for the defense.
All right, so the state has filed motions to increase bond in each of the cause numbers. Is that correct, state?
Yes, Your Honor.
Are there going to be witnesses presented?
No, Your Honor.
And defense, do you have any objection to witnesses not being presented?
No, Your Honor.
All right, then I'll hear argument.
Your Honor, Mr. Molinax was here for a bond hearing on, I believe, the 16th, at which Judge Angelini agreed to set bonds in each of these in each of these cases at $4,000. Not long after that hearing on the 20th, Mr. Molinax picked up a new offense, so we would ask that the judge, or this court, excuse me, double the bonds in each case, as well as amend the conditions and add GPS monitoring in each of the class members.
Brief response, Your Honor.
Yes.
No objection to the GPS. However, we would request that the court consider leaving those bond amounts. They are more than one, and the new offense in question is, there's some factual issues that we would argue aren't a black and white case. There is its own bond amount for this new felon in possession, and Mr. Molinax does have significant time in custody. We are not retained on the felon in possession yet, and we don't have any bonds that are being posted on the new case.
All right, and can I see the third motion?
Which cause number, Your Honor? So I can
I
pronounce?
have 24 and 25.
Let me just print 8-6 as well. I apologize.
And sir, in Kendall County, we're just waiting for your attorney. He's conferring with the state. right, this is what the court is going to. And each cause number, the court will grant the state's motion. Bond in each cause number will be increased to $8,000. In each cause number, the court is going to order full GPS, waive fees, and the plea deadline date is extended to October 2nd, and it will not be extended further. Is there anything else?
Nothing from the state, Your Honor.
Not from defense, Your Honor.
All right, thank you.
Thank you, Judge.
May we be excused for now?
Yes.
Thank you. Your
Have
Honor.
a good one.
Okay, Mom.
All right, we'll wait for her to line up the next contestant. Let's try the next contestant, Louisiana. See how this drama plays out.
The time is
Whoops.
10:06. My name is
I still
Carolyn
have that
Stapleton.
queued up. That's
I'm
a
serving as the
preemptive
chairman
denied.
on today's parole panel. My colleagues will be joining us by Zoom, Steve Prater and Jerry Ledoux. The panel today is at DOC headquarters. Today, our remote location is LaSalle Correctional Center. With the staff at that facility, do you have anyone in there with you, sir?
Ma'am, can you hear me?
Yes, sir.
No, ma'am, there's no one in here with me. There's someone behind me outside.
Worry about it. Okay, that's okay. We're not going, you're good. Okay, will you please introduce yourself, say your name and your DOC number, please?
My name is Ernest Sharp. My DOC number is 78990.
Okay. All right. I'm going to read some information record, and then I'm going to ask you to verify it at the very end, okay?
Okay.
All right. You're a first-class offender. Your offense is for distribution of controlled dangerous substance, meth. Your sentencing date was June 21st, 2024. You were sentenced to 5 years at hard labor. Your parole date is August the 26th, 2025. Your good time date is February the 26th, 2026. And your full-time date is May the 27th, 2029. Is that correct, sir?
Yes, ma'am.
Okay. Okay, is there anything that you would like to tell us as to your explanation as to why you're incarcerated today and why we should release you early?
Well, ma'am, I'm incarcerated today because I passed over some methamphetamine to a confidential informant, which was a previous friend of mine, and that's why I'm incarcerated. And to be released, I have two sisters that are, my mother just passed away this 2 or 3 weeks ago, but I have two other sisters that are, their health is bad. I need really to be there for them and help them as best as I can, and help with my family. I have a son that's mentally challenged that I'd like to be there to help with him and be a productive member of society.
Okay. All right. Normally at this time, if a warden or someone is in the room, when we ask them if they have anything that they'd like to say about you, the person that's right outside the door, or did they know anything about you, or they're just a member of staff?
They know about me. They've known me since I've been here.
Okay. Just, you can ask if they'd like to step in and make a statement, just so we.
I'm sorry. Would any of y'all like to step and make a statement for me? I mean, you work with me.
Yeah, I work with you in the kitchen.
Yeah. This is Mr. Street. You want me to hand the mic over to him?
Okay.
Okay. I guess.
Oh, yes. Hello.
Okay. Is there anything that you would like to tell us about Mr. Sharp?
I worked with him from the time he got here. Well, after about a week he got here. in our kitchen
Uh-huh.
up here at the prison, and he's always been patient, very explanatory on everything that he's done. He's always been slow and methodical with everything he's done. He's been honest. If I've asked him a question, he's always given me a straightforward answer. I've really never had any problems out of him. As far as I know, he's always listened to everything somebody's told him, and in every encounter I've had with him, he's been very, very patient and understanding with all of our rules and regulations.
All right, Mr. Street, thank you very much for your input.
Yes, ma'am.
Okay, thank you.
Thank you.
At this time, we have some supporters, and the first one is going to be your sister, Miss Latham. Are you ready to speak, Mr. Latham?
Okay, can you hear me? My phone is unmuted now.
Yes, yes.
Yes, ma'am, I'm ready.
Okay, what would you like to say about your brother?
Excuse me if I'm a little emotional.
That's okay.
Our family's just been through a lot. I'm sorry. Our mother just passed away a few weeks ago, and I'm just emotional still. But what I want to say about my brother is that he's been a very good human being his whole life. He was a very well-respected business owner in our town and very well loved. And people in our town are still constantly checking on him, praying for him. He's always been known as a very good person. I still don't hear bad things about him. Everybody loves and supports him. He's always been a really good person, but he's always wanted to help the underdog. And I think that he went above and beyond to help people, especially as a business owner in our town. He went above and beyond to help people, but he always helped the underdog. And sometimes when they're drowning, they'll pull you under too. And I think that's kind of what happened. But I think he learned his lesson and he'll never do this again. He's a good Christian person. And I don't think he'll ever do anything like this again. He'll be a productive member of society again. And I do believe that he's going to be just fine if he's released. We need him. He's our only brother. My two sisters are sick, like he said. Both of them are on disability, and one of them is not doing well at all. We just really need him out to be able to help with everything since our mother passed. But even beyond that all aside, I believe that he deserves to be out because I think for what he did, he's served it his time, and he has honestly learned his lesson. I believe he'll get in a good church and a good recovery program, and he'll be fine.
Okay, thank you so much, Ms. Latham, and my condolences on the loss of your mother.
Thank you.
Okay. All right, now we're going to go to Cindy Sharp, your ex-wife.
Yes, ma'am.
Ms. Sharp? What would you like to say? You need to unmute. Can't hear you. No, not now. Still can. Y'all have any suggestions? Click your microphone. Click your microphone. Do you see that? We still don't hear you. Okay, your microphone would say audio in the left-hand corner of your screen. Look for that. Are we just, what, you're gonna call her? Okay, we're gonna call you. The staff is gonna call you. Okay, ma'am, what would you like to say about your ex-husband, Mr. Sharp?
I'd like to say that, he is my sister would get him out. I need help with my son, and he is a great person, and he's do anything in the world for you. And I think he just got down to a low point in his life, and he was looking for something. But I think he has learned his lesson. And like I said, his mother just passed a few weeks ago, and we just need him out. And I just think, like I said, that he has learned his lesson.
Okay, thank you so much, Ms. Sharp.
You will. Can I hang up now?
She said, they said, okay, yes, ma'am, you can hang up now.
All right, thank you.
Okay, thank you, Ms. Sharp. Okay, Mr. Sharp, at this time, I'm going to turn over your case to Mr. Prater. And he will continue the interview, and then later he will cast the first vote. Mr. Prater?
Okay, Mr. Sharp, are you doing okay today?
Yes, sir. Yes, sir. Thank you. And yourself?
Okay, first off, you said you handed over some drugs to somebody.
Yes, sir.
Is that the same as selling, distributing?
Well, I didn't sell them. I didn't sell the drugs to him. He had been up with his mother days in, days out, and I told him I didn't do drugs anymore, and that he asked me if he could find out from somebody where he could get some meth, and I told him, I said, I don't know. Well, he kept on calling, and I just broke down, and I said, well, there was a fellow that come by my house, and I said he had something. He was staying up day and night with his mother. And actually, he is a deputy. I mean, a lieutenant here at the facility that I'm housed at. Been here the whole time that I've been here. We talk. I don't have any animosity to him. I could just say this: he probably saved my life in a roundabout way. But he asked me, and I finally I gave him some, and I told him, I said, I'm not selling it. I'm not no buyer, seller, whatever you call it. And I just handed. I mean, it was.
Did he give you any money back?
He didn't give me any money, but after he left, and the next day, there was a $20 bill laying on my counter that I never knew who left it, because I had Christmas tree there and some decorations, and it was in those decorations there was a $20 bill, and I know that he had to have left it. And that was not for the. I don't know why he left it. That's when I realized that I probably did the wrong thing.
Where'd you get the dope?
Where did I get the dope? From
That's it.
A friend, and he drove over to my house. He's actually incarcerated here.
Okay, according to the police report, you sold dope 2 different times, sold methamphetamine 2 different times.
I gave it to him. Yes, sir. I gave it to him both times, but I didn't sell it. I never took any money for it.
Well,
he bought Mayhaw jelly. He bought Mayhaw jelly from me, and I don't know if they've got that crossed up, but I did not take money for that. But he did buy Mayhaw jelly because I make a lot of Mayhaw jelly.
Yes, sir. In the Mayhaw jelly, somebody put the methamphetamine, a bag of it, in the lid of the Mayhaw jelly. Is that correct?
On one of them, yes, sir.
Okay. Well, see, you kind of, you kind of. Never mind. I don't want to get into all that.
I'm
with you.
sorry. But that's the only one that he got.
Okay, what was your sin? You pled guilty to one count. You were charged with two counts. You pled guilty to one count. You were
Yes,
given
sir.
a 5-year sentence. How much time have you been in jail?
Almost 16 months. I think it may be a little more than 16 months now.
Have you had any programming, substance abuse programming?
I went to DC2 to get a program, the classes, and they didn't keep me there but 2 days and sent me to DeQuincy. I stayed down there 2.5 weeks at DeQuincy to get some good time classes, and because of my medical, they shipped me back here.
Okay.
And so because of the insulin and stuff that I was taking, they sent me back here, and I've been back here ever since.
Okay.
I've never been in any confrontation with anybody here.
Have you ever had any pre-release programming, re-entry programming?
No, sir.
Okay. Have you ever requested that?
I have. That's when they shipped me to DC2.
Okay. All right. I don't have it. When is your good time day? When are you getting out anyway?
Well, February is my DS date. I think it says on my rep sheet DS in February 20 next year, but it's on the 26th of February, I think.
So you're getting out in about 5 months anyway, correct?
Yes, sir. Yes, sir.
Okay. Madam Chairman, that's all I got.
Ms. Ledoux, do you have any questions?
No, the offender does not have the required classes needed and doesn't appear to have the time to do those. So I don't have any other questions.
Okay. All right. And I have no questions either. So at this time, the panel will vote. Each member will state their vote and the reasons. And we'll start with Mr. Prater because he's leading this case.
Okay. My vote is that this request be denied because of the fact that I think he's still denying his drug use, his drug crimes of distributing something as serious as methamphetamine. I think he's not being truthful with us. He hadn't had the classes. He's only served a number of months on a 5-year sentence, and he's going to get out in 5 months anyway, regardless of what we decide, just because of the state of Louisiana laws. And so my vote is to deny this request for parole.
Okay. Ms. Ledoux?
Mr. Sharp, my vote is to deny based on the fact that you lack the necessary programming.
Thank you.
Okay. And Mr. Sharp, my vote is to deny also, and I agree with Mr. Prater. I think you were very, you had to ask a lot of different ways how you did things instead of you just coming out and saying that you put the dope in the Mayhaw jelly jar. So that was kind of unnecessary. So have a unanimous vote that you've been denied today. The time is 10:24, and we will be, this concludes our business at this facility, and we're closing out at LaSalle Correctional Center.
Denied.
You know, I thought for a minute that my preemptive denied when we first went there might have been misplaced, but turns out it wasn't. Thank you, Bailey, for the $1.99 super sticker. Thank you, Michael, for gifting me a membership to my own channel. I appreciate that. That's twice now. I keep the ability to receive gift memberships turned on because in my personal account I've received them from other channels that I follow. But yeah, that's twice I've been gifted now to my own channel. So thank you. Now I can watch my own pre-show, and I suppose call into my own pre-show to be a guest. I don't know. There's a lot of options there available to me now, so I appreciate that. But seriously, thank you for the support. We got a couple minutes left. Let me see what we can do with that couple minutes. We could... This makes the most sense. Let's go back to Judge Boyd, I think.
Lauren Epstein for the state.
And are you Mr. Romero?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same David Romero who's placed on community supervision in 2025 CR 002660 for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on April 16th, 2025 for a term of 5 years? Is that you?
Yes, ma'am.
State?
That's violated condition number 1, which reads on or about the 24th day of July, 2025 in Bexar County, Texas, the defendant David Romero committed the offense of criminal mischief in violation of condition number 1.
How do you plead to that? True or not true?
True.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 4 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4. The court will find violation of condition number 1 true. And let me repeat that because I said it incorrectly. Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 4 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Your Honor. The agreement is to deny state's motion, alter and amend conditions to add GPS tracking for 60 days, MRT, and to follow the TAP evaluation recommendations.
That is our agreement, Your Honor.
What has he done since he's been on probation? Has he completed anything? Any objection to the court reviewing the court summary?
No, Your Honor.
No objection, Judge.
Right, let me see. All right, so from reviewing the court summary, it doesn't appear that he is an appropriate person for probation. It says here that he struggles with reporting.
Well, I was going to like downtown and then to the one on Military, so I had me go back and forth.
So they have you on a specialized caseload. And they have violation of program or service conditions, and it's a gang supervision. Does anybody know what that is about?
I met with them, that's about it.
I'm sorry, what?
I met with them and they said they were gonna just do house visits or something like that.
Yeah, but he has reported, Judge. There's no violations of him not reporting.
Yeah. Here in front of people.
And then the new number 1 that he's pled to, what is that about?
Some type of utility pole. There was something was going on with the utility pole, right?
Yeah.
Okay. City property, therefore that's your criminal mischief.
So what is happening with that?
For the house, it was there, we caught on fire and I was just helping out the neighbor. And it was some burnt stuff.
Well, I need to, because he's telling me something different. You're not under oath, and I'm sorry, you're gonna have to speak up because the court reporter is trying to hear, but just give me a moment.
But Judge, on his County Court 5 criminal mischief case, once we're done here, we anticipate going over there, pleading to that case to resolve the situation.
So what was the alleged criminal mischief about? He's saying that he was helping a neighbor with a fire and a telephone pole?
That telephone pole had burned?
No, the house caught on fire.
All right, here's the thing. You want to tell us what's going on, because if you want to tell me
I was
what's
taking
going
off
on,
the black
no,
mark.
stop. If you want to tell me what's going on, I'm going to swear you in. And anything that you say can be used against you in the criminal mischief case.
Let's hold on a second.
I'll be
Let's see, look up the police report.
Yeah, it's loading right now. I'm pulling up the Mac. And then if I can have the paperwork for the person who's on Zoom, it's a bond issue. I'm sorry. Ms. Abrams, this is David Romero. I'm trying to figure out, they say there's a violation previous. All right, thank you.
I think the state has the answer for you.
Yes.
Your Honor, this case was filed, the victim in this case is the city of San Antonio, and it's regarding the alleged striking of the utility pole with a hatchet, causing damage to said pole.
No. Criminal misjudge, he's got no prior MTRs. We're asking the court to give him the opportunity to continue on deferred adjudication. And he has an elderly father he cares for, and he's trying to.
All right, so here's the thing with the elderly father you're caring for, you need to be thinking about that while you're doing actions that you should not be doing. You understand?
Yes, ma'am.
I'm going to give you a choice because I do see that you don't have any prior violations, and I'm sure the city of San Antonio wants to be paid if there was damage. I can revoke you and sentence you to 2 years. You'll receive credit for any time that you've served, or I can follow the recommendations from the state in probation. Alternate amend conditions to include GPS, and you'll only be allowed to work in nothing else, and the MRT course. Which do you prefer?
Second one, the MRT one.
All right, the court will deny the motion. Alternate amend conditions to include the MRT course and GPS partial for employment only, and waive GPS fees. Probation, is there anything else you would request?
Work for outpatient treatment might be waived and documented over supporting.
All right, there's to be monthly UAs, outpatient treatment with probation, and 30 sober meetings in 30 days. All right, thank you.
Thank you, Judge.
Thank you.
We'll work on the next.
All right, do y'all have the
Okie dokie, friends, it is time to call it a day. I hope you enjoyed it. I know I did. I enjoyed it so much that let's do it again tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. Welcome to all the new channel members today, and thank you to Bailey and also to Michael for gifting memberships. Very much appreciated. I'll be back tonight as well for Sidebar, 8 p.m. Eastern, 5 p.m. Pacific, with the triumphant return of Ashley tonight. So that should be fun. And I believe we're going to discuss juries in this short attention span TikTok world. What kind of a role does the fact that people can't pay attention to anything for more than about 10 seconds, what role does that play in the quality of juries that we can have? So that should be a fun discussion. So we'll see you all tonight, if not then tomorrow. And in the meantime, go have yourselves a great day. Take care. God bless.